Madam.
Submission, Lord, sir. Lord, in MFA matter, my Lord, I was questioned the Interstate Tribunal award for recovery of the contribution, my Lords. My Lords, already notice was issued. Now it is await, my Lord. Lord, at any moment, my Lord,
Yes.
at any moment, my Lord, they may be attached to my account, my Lord.
When is what?
Award, my Lord, there is a delay of, my Lord, 1.5 year, my Lord. My Lord, I am ready to, my Lord,
Let it come.
tomorrow, my Lord.
Yes, tomorrow.
Please, my Lord.
Yes, next. MFA next week. Huh? MFA MEC. They'll come. Every day,
next
all of you are
next we are
mentioning-
facing attachment.
Huh?
Facing attachment.
You write that, they will list it tomorrow.
Next week.
Give it to the court of
Please,
appeal,
please.
all of you.
Yes,
Not to mention. Everything, give it to the court officer, write the reason, it will come.
My lords, on submission, my lords. One GMCPC matter, my lords. Petitioner wants to withdraw the petition, my lords.
That also will come.
My lords, it
Give
may
the memo to
kindly taken at 2:30, my lords. There is urgency.
the withdrawal.
Please, my lords, the petitioner and respondent are brothers, my lord. Respondent is has got a heart attack and admitted in the hospital, my lords. So at this stage, the petitioner wants to withdraw the case and to maintain cordial relationship.
Take that and take it up at, before 1:30, I'll be raising at 1:30.
Please, my lords.
Next.
Page wise adjournments. Page number 1, seal number 1 to 6. Page number 2, seal number 7 to 14. Page number 3, seal number 15 to 23. 20. From admission. Page number 7, seal number 37 to 39.
Serial number 38. Serial number 38. Need to file a necessary application.
You need to file?
Necessary application. Stay affidavit ಹಾಕ್ಬೇಕಾಗತ್ತೆ.
You are not filed.
No, fresh matter. Just a fresh matter. I'm waiting for the affidavit from the concerned manager. So
Along with the MFA, stay won't be filed. Is this matter next week?
please.
Yes.
Seal number 40 to 46. Page number 8, seal number 47 to 51. List number 1, seal number preliminary hearing, seal number 1, Patil Mahantesh.
No
Mahantesh
representation.
Patil.
After 2 weeks. Next.
Seal number 2, VC Dhanaya Swami.
Appearing for the petitioner, my lord. JDR, your lordship prepared an writ petition. Your lordship, the petitioner, your lordship has filed a IA number 3 for staying of the execution proceedings. The petitioner, your lordship, has challenged the ex parte decree. The respondent, your lordship, has filed a suit for.
Decree proceedings are challenged. There you will get the stay, not before the executing court.
No, my lord. What happened? The respondent, your lordship, has filed a suit for recovery of money. That suit came to be allowed ex parte, my lord. Being aggrieved by the said order, the present petitioner, your lordship, has filed a miscellaneous before the principal civil judge at Gangavati. And in the meanwhile, my lord, the respondent has filed a execution petition. In the execution petition, my lord, the petitioner, your lordship, has filed a memo for staying the execution proceedings till disposal of civil miscellaneous.
I said, why will the executing court do it?
Because the.
Seek this relief before in the
Yeah.
miscellaneous application.
Yes, exactly, my lord. But what happened? There is a delay in filing the civil miscellaneous. For that aspect, my lord, we brought to the notice of the.
Then the court will not stay as long as judgment and decree is in force. It is not interfered by any appellate court. There is no reason for the court to stay.
And
the proceeding.
our application, stay application is also pending in civil miscellaneous.
You pursue, this can't be done. Please come.
My lord, one direction may be issued to dispose the IA regarding. My IA is also pending before civil miscellaneous.
Court.
Same, the principal civil judge at Gangavati, my lord.
Will direct.
Please.
The present petition is filed, seeking the following prayer. The respondent herein has filed a suit for recovery of money and the same was decreed. Thereafter, they have initiated the execution proceedings, decreed ex parte, and thereafter execution proceedings were initiated. The petitioner has filed a miscellaneous questioning the ex parte, miscellaneous number
Miscellaneous number 3/23.
3/23, questioning the ex parte order passed by the ex parte judgment and decree passed by the court with a delay of 1.5 years.
Please.
And the same is pending consideration. It is a case that in that they have sought for an they have filed an IA seeking stay of the proceedings. In the meantime, when the respondents are proceeding with the execution petition, they have filed an IA before the executing court to stay the proceedings that came to be dismissed by order impugned. Hence, the petitioner judgment letter is before this court. The next, the trial court, while dismissing the application, that the decree was passed in the year 2021 and the decree holder has to enjoy the fruits of the decree, and the JDR has not shown sufficient grounds to say the further proceedings. If the same is allowed, injustice will be caused to the decree holder and will be caused to the decree holder. The court has also observed that the JDR has filed the present application to tag on the matter and to delay the proceedings. Hence, there are no grounds to entertain the petition. Accordingly dismissed, when counsel for the petitioner submits that till the application that is filed by the petitioner seeking stay in the miscellaneous is decided, there shall be stay of all further proceedings. This court, having heard the counsel for the petitioner, is not convinced with the submission of the learned counsel. When an ex parte decree and judgment is passed, and when he has questioned the same in the miscellaneous, he needs to get an order seeking for the stay of the further proceedings. The same cannot be done by the court in the execution proceedings. In that view of the matter, this court do not find any reasons to interfere with the order impugned. Accordingly, writ petition is dismissed. However, considering the fact that IA number,
IA number, applications are pending, my lord, but as per instruction.
we can't help it. You don't even mention which application, what is the number, what is the miscellaneous number, how can the court grant direction?
Until delay come down, my lord,
It is not like give ticket to my to my place without even telling.
I am
where you want to
not
go.
thinking on that way, my lord, but only delay is 1.5 year. That is
Yes.
main problem.
I thought if you give the numbers,
Please.
I will ask the court to consider your application
Yes,
expeditiously.
I'll give.
You don't furnish it.
No, I'll furnish, my lord.
The trial court, where is that pending? Before which court?
The principal civil judge, my lord, Gangavati.
He will give the details.
Please.
So and so is directed to consider the same expeditiously in
Publish.
accordance with law.
Publish.
Yes.
Seal number 3. Sachidananda.
My lord, this matter pertains to the same matter wherein my lords heard me the other day, my lords, regarding payment of interest on delayed gratuity, my lords. My lords have stated this is pertaining to this.
For this matter,
My lord, this is
arising out of the same.
arising, my lord. It is a different employee. The petitioner bank is the same.
Give that order. Only the amount will change.
Only amount changes, my lords. That's it.
Just look at it, the same order, just the amount will change.
My lord,
Next.
respond number 1 and 2, MB convey, my lords. And
Also,
note,
like in the
please,
matter.
please, grateful.
Yes, next.
Seal number 4. Ravikiran P. Pawar.
Number 4. Yesterday only I received the copy.
Your Lordship, I am appearing for the petitioner, Your Lordship.
Seeking 2 weeks time to file the objections. Your Lordship, may kindly peruse. A representation was made on 5/1.
When the petition comes for preliminary hearing,
Please.
we have to hear whether interim order can be granted or not.
There is no interim violation, only a mandamus to consider the
For
representation.
mandamus, why?
No
time is
interim order
required?
has been sought, Your Lordship.
What is the mandamus they're seeking?
Adolage,
Mandamus to consider my representation, my lords, at annexure C, Your Lordship.
73 lakhs to the petitioner. For this, objections are not required. You please get instructions. We will dispose it off. You can consider and pass orders.
Correct, but representation was submitted on 5th January. And this writ petition was filed on 20th January. Within 15 days, writ petition
The
is filed.
counsel appearing for the, which respondent? Which respondent?
Respondent number 3, my lord.
And
He is
counsel
appearing for the respondent number 3, your lordship.
Give specific instructions. List this matter on Thursday.
Please.
Yes, next.
Grateful.
Number
my lord.
5.
My lord, I appear for the petitioner. The impugned order is in Kannada at Annexure A. I know if your lordship wants a English translation, I can provide it.
Yes.
My lord, we have sought, my lord, it is a partnership firm. There is a change in the constitution. And as per Annexure B, my lord, we have filed the required form 5, bringing it to the notice of the respondent that this will have to be noted in the register of firms. My lord, the respondent is now asking us again, all over again, to sign and furnish another
So
form.
what is this array of respondents? Respondent again is registrar of firms or it?
My lord, that is the only relief available to me.
No, there are no other, which department it is? Which
It
which
is,
part, which you?
My lord,
what
there is no
the
other
instrumentality?
other relief available to me except filing a writ petition. And my lord, earlier this honorable court has also entertained similar writ petitions and have given directions. My lord, my learned colleague there is there. He will give your lordship a judgment dated 19th February 2025. My lord, in writ petition number 23779 of 2023, a similar order has been passed and
No, it's not about the similar order. What is this registrar of firms? And again, is that a writ petition?
my lord, that is the only relief available to me. I have no other relief
It's not
available.
that. Who is he? He is functioning under which provisions of what is the statutory function?
Under the Partnership Act, my lord. He is the registrar of firms. Under the Partnership Act, take section 63.
I am not convinced, sir. The petitioner shall argue on the maintainability of the writ petition. List this matter on Wednesday.
My lord, your lordship can give it next week, my lord.
It's next week only. Next week,
25th.
Thursday.
26.
20. My lord, 26th, I have some inconvenience. Would your lordship have it next week, my
Any day
lord?
you want.
Next week, my lord, starting 4th March, my lord.
Yes, 4th March.
Lord, appearing for the petitioner. My lord, the petitioner has filed a suit for specific performance of contract. My lord, against the defendant number 1. And my lord, in meantime, the notice has been gone and appeared and written statement has been filed. In the meantime, that defendant number 1, my lord, who is the son of the defendant number 5, my lord, he is a senior citizen. He filed in a my lord, assistant commissioner before he has entered into an agreement of sale, and we have paid the my lord 5 lakhs rupees for advance amount, and my lord, so he has not performed the contract. So we filed a suit against the defendant number 1. In meantime, the father of the my lord, he filed a senior citizen who has my lord in turn he has entered in the agreement. My lord, implementing application I number 9.
Please come to the order.
Yes, my lord. Your lordship kindly see, notice has been gone to the proposed defendant number 1.
The order, first let us read the order so that the facts will be clear to the court.
Yes, ma'am.
Where is impugned order?
Impugned order, my lord, last page number, typed copy, my lord, 95. Bottom,
90?
95, my lord. Bottom, that is, my lord, proposed number of times you have issued a notice on, my lord, 9/10/2025. My lord, reissue proposed.
When did you file your IA?
My lord, 2000, my lord, 23. Number of times you have paid. What is necessary? Number of time, your lordship kindly peruse the order sheet. Every time you have paid. But hand delivery, hand summons, And also I have paid the hand summons, process is paid, but we have not taken,
Right from 2023 till 2026.
yes, that is true, my lord.
Paying for the process, that means its application is not necessary for you. Has it been that, you would have taken some steps. Forever you will be
That
taking
is-
hand summons.
That is, my lord, he has done, but we have paid the hand summons only because of process paid hand summons, because he is a necessary party. In turn, he has sold the property to the, my lord, defendant number 2 and 3, 4.
If he is a necessary party.
Yes, my lord.
Nobody is stopping you.
Yes,
Court
yes,
has never said,
yes.
don't take notice.
My lord, one opportunity, I will immediately, my lord, will take it because he is necessary party in this agreement, my lord. Because father has sold the property in turn, my lord, 2, 3, 4 is a 10 acres of land is there, 3 items of land. So we will immediately, my lord, if after notice, my lord, we will take one chance. Now the evidence is posted and started evidence. So, my lord,
You have never taken, you have never paid the
yeah,
process.
no, your lordship kindly say,
That is if a process paid.
we have paid, but it is returned unserved. It is returned.
So where is?
Your lordship kindly see your lordship, page number 88, your lordship kind, 88. Every time, my lord, notice issued, PF D5 issue notice, and process proposed defendant number 5 paid, colon, reissue notice proposed. Every time we have paid, my lord. Every time, my lord, your lordship kindly
Reissue notice.
Notice.
Process is paid.
paid. Yeah, you have paid, my lord.
That is not, if that is the case, why would the court say that right from 2023,
That
you
is,
have not paid it?
but that was returned. Notice was no returned, my lord.
The land counsel of the petitioner shall place before the court the material to show that he has paid the process as argued before this court. Please this matter next week.
My lord, in meantime, my lord, the
No,
matter is
that is-
posted.
that
I have gotten a document.
That is your suit. I will not stay.
My lord, your lordship kindly have it at least next week date, because I will produce the document. I have paid the process.
Thursday?
Yes.
Yes.
Seal number 7.
Please, Lordship, sir, the copy to Council Shivsai as Patil, my lords. Since he refused to take, I may be permitted to serve the same on
Refuse to take.
the one who appears for respondent number 2 and 5, Shivsai Patil, my lords.
Shivasai M. Patil.
Please.
Has
Yes,
refused to take.
refused.
Why?
He does not appear on behalf of National Highways, my lords.
He?
As he says that he does not appears for National
Who
Highways.
appears then for national highways?
BP Matpati, my lords.
Mr. So-and-so is directed to take notice on behalf of respondent number 2, 3 and 5. It is submitted that Mr. Shiva Sai M. Patel, a Patel is not appearing on behalf, is not representing the National Highways Authority.
National Highway,
When,
please.
when do you want?
I am the
Monday, my
respondent.
lords.
Monday? Yes,
Please,
next.
please, please.
Okay. Seal number 8. Devatyam Court.
Please, my lord, I appear for petitioner.
Where is
This
affidavit?
the affidavit. Please, my lord.
Have you
I
seen
served a
affidavit?
copy.
The time they have asked, my lord, is up to next 4-5 months, my lord. The outstanding balance, my lord,
2 crore 21 lakhs.
Lord, as
The petitioner company is ready to deposit 50 lakhs on or before 24th. You were saying 2 weeks?
Please,
You were saying 2 weeks, some amount.
but the thing is, my lord, there is a,
You have submitted before the court, that's how it is adjourned.
yes, my lord, within 1 month I will
Or
pay.
before 24/5. You said yesterday, if I remember,
Please, my lord.
2 weeks and 4 weeks, that's what you said. That altogether 6 weeks. That is 1.5 months.
No, my
No,
lord.
no, where till
Yesterday I
you have gone?
submitted 50% of the amount I will deposit within 4 weeks, my lord.
4/6/2026. That is how many months? 4 months. Yes.
that's the total outstanding balance, my lord. It is 2 crores 42 lakhs 41,140.
21 lakhs.
What is the calculation as per this?
My lord, I have taken data, my lord. As on yesterday, they owe 2 crores 42 lakhs 41,141. Lord, at least 50% of that amount, let them forthwith deposit, my lord, because it has gone NPA and also huge amount causing losses. And
Ultimately, in 4 weeks, 4 months' time, if something is happening, bank should be happy.
but to show the bona fides, at least immediately let them some.
No, for any installment is not paid. You don't have to wait till 4 months. You can start the proceedings from where it is stopped.
No,
For
so much.
example, if this 50,000 is not paid, 50 lakhs is not paid by 24/3/2026, you are at liberty to initiate to proceed with the proceedings. Now, where is the stage?
Now, my lord, section 14 order has been passed by the CJM
The
court.
proceedings will follow. So no injustice to you. You don't have to start everything afresh.
Lord, this, at least this amount is, 2 crore 42 lakhs, 44,141 instead of para number 1.
Is there? Close the door so that it will be effective. Every day I have to tell. Yes.
My lord, in the paragraph 1 of the affidavit, they say that it is 2 crores 21 lakhs 91,461. Instead of that, as on yesterday, my lord, it is 2 crores 42 lakhs.
1 minute. Where do you get that?
Para number 1 of the affidavit, yes.
2 crores?
She has stated that it is.
That is in the impugned order, my lord, page number 15.
Interest will accrue after that. 2 crores?
2 crores 21 lakhs 91,000.
And what I'll say is,
Yes.
2 crores 91 lakhs.
21 lakhs.
21 lakhs?
91,461.
That is what you have stated. According to him, what is the amount?
According to me, 2 crores 42 lakhs 44,141.
150?
1.
So what I'll say is, in the last, what they are going to pay on this, the remaining amount they stated, no? Whatever is the remaining amount, you please communicate that they should pay. That's what I'll record. Last installment.
Yes, ma'am. But at least.
Hardly know the difference is about
20
lakhs is the difference.
Yes,
20
That
lakhs.
they would be paying in the last installment.
At least the first installment, let them pay it at the earliest point of time, as they submitted yesterday, my lord.
The present petition is filed seeking the following prayer.
Plus, before that, I will be directed to take notice for the respondent. Yesterday, I will be directed to take notice for the respondent.
So whenever I say notice, in a final order, it should be the order on the order sheet, not in the order.
Please, my lord, one submission, my lord. The impugned order is 29/1/2026, my lord. Within 12 days, my lord, it amounts to 20 lakhs, my lord. That how they have calculated.
Then both of you decide.
No, my lord. No, your lordship can pass an order. Only thing is within 12 days, my lord, it is 21 lakhs.
Want, I can pass it some other day. You get the clarification how it has become. That is better. I'll have it.
That in respect of that amount, my lord, they may clarify it.
No.
Please, my lord.
My lord, as it stands, they can't even maintain the writ petition section
Those
17, my
disputed
lord.
questions this court can't enter into. So if you want, I'll adjourn this matter to Wednesday. By the time, go to the bank, find out why it has become 2 crore and 40 lakhs and all.
20 lakhs after
And
the
and
impugned
this
order.
affidavit, by correctly getting all the details, even if you get the correct details also, again, by the time you pay the amount, again, the interest will
Remaining
accrue.
amount, yes, ma'am.
So whatever it is,
Yes,
you have
we
to
agree.
pay.
Yes.
So for better for precision, go to the bank and get the correct picture. This is the matter on Wednesday.
Please, till then, my lord,
Tuesday, my lord, 24th. Yes, ma'am.
till then, my lord,
Plus, that, my
take
lord,
coercive steps.
will come in the way. my
by the
lords.
bailiff.
My lord, she's not entitled for any interim stay, my lord. We want to show the bona fides, my lord, in line with the submissions made yesterday, they have not filed the affidavit.
I have.
My lords were, plus that the amount which they had agreed to deposit 2 weeks, the first installment would be paid, and thereafter
No, my
4
lord,
weeks, 6
actually,
weeks in
within
altogether.
1
she had
month, my lord,
made a
I said.
submission. And now this particular split up, it amounts to rewriting of the.
Wednesday, when the court is going to pass an order,
Yes.
by that time, some amount has to be deposited.
Yes, ma'am.
That is
Please.
how you bifurcate and file the affidavit.
Please.
Yes.
The interim order, ma'am.
That's what I'm saying, till Wednesday, not to take any coercive steps.
Yes, ma'am. Hand delivery, ma'am.
Matter on, he is there, he'll
Yes,
inform.
I'll intimate.
Huh?
Please.
I'll intimate.
Yes,
Grateful.
yes, next.
Still number 9, Saurabh Hegde.
Representing petitioner, my lord, amendment to plaint came to be rejected, my lord. Kindly come to, my lord, annexure A.
What is the amendment that is sought?
My lord, page number 53. Lord, before going to the amendment, my lord, this suit had already decreed. Kindly come to page number 10, my lord, annexure A.
You're the plaintiff in the suit.
Plaint-
When
plaint-
was the suit?
Plaintiff.
Suit is of the year 23.
23, my
When
lord.
was it decreed?
19 December 2025, my lord. Partition suit. I am the sister, my lord. Suit got decreed and they were placed ex parte. They did not come to court even after service of notice. Then they filed an appeal, matter remanded back. Lord, kindly come to the written statement. They had not filed written statement also. Then after that, in the year 2025, at page number 47, my lord will find, they file a written statement on 26/6/2025. Then, my lord, they tell about the existence of some deed that they have already transferred some of the properties. Then immediately I filed an application for amendments saying that sale.
To that affidavit.
My lord will find at annexure page number 53, my lord. In the first paragraph, may I read, my lord? Lord, from the third line, the property was transferred by the deceased grandfather of the plaintiff in favor of his son, that is so and so, who is the father of defendant number 225. Page number 53, my lord.
No, you're seeking that to declare that deed as.
Yes, only that, that's it. I'm not.
The present writ petition is filed. Agreed with the orders passed in I number.
Lord,
Where is the order?
Order can be seen at annexure A, my lord.
Page number.
Page number 10 onwards. IA number 2, my lord.
Passed in I number 2 invoice number 22 of 2023, whereby the petitioner's application for amendment of the plaint is rejected. The suit is filed for partition and the suit was decreed ex parte and the defendants have preferred an appeal. In the appeal, the matter was remanded to the court, and while after the remand, they filed a written statement and have taken certain pleadings whereby it is stated that a sale deed is executed.
Notice is not at order, my lord.
I am not disposing of.
Oh,
For interim order also, I'll record the reasons.
Yes.
That in a seal deed dated 8/9/1977 is executed. Hence, the petition has sought for amendment of the plaint by incorporating the same, and also sought the amendment of the prayer by seeking a direction that the sale deed executed in favor of the defendant number 2 as null and void. The court, by order in June, has dismissed the same, considering the submission of the land counsel, that as these facts are brought to the notice of the plaintiff on 26/6/2025, which made him to file the present application. There shall be stay of all further proceedings in so and so. Notice to the respondent, petitioner to take out hand summons on the counsel appearing for the respondent and file a memo by 16th of March, or else the stay granted by the court stands vacated.
I may be permitted to, my lord, comply the office objections.
His office objections shall be complied within a week.
Great.
Yes, 10.
Seal number 10. Cast your vote. Girish Dharwad. Please.
Nothing could be materialized before the mediation.
What happened?
No compromise.
They did not agree for any of the proposal, and ultimately I'm told that they said, whatever is allotted, you take that only.
No, what did they say? Whatever is
Other
allotted,
proposals, they did not accept. This is, of course, Manoj, we should not reveal what happens in mediation, but Manoj, on a lighter note, I was told that Manoj, they did not accept any of our proposals, and ultimately they came to say that, no, whatever is granted by the court, you take that only. But that apart, Manoj, there was no Manoj. We tried our best. In fact, my senior was also there.
We'll confirm the order. The present deputy, where is the order?
One submission before, just one document, because there was a court commissioner who was appointed in the trial court. And there is also one observation which has been made by the
Please use the mic. I'm not able to hear.
There is a court commissioner who was appointed by the court in the trial court. And the court commissioner has submitted his report. Just one line I like to read, and thereafter I'll not intervene. And this
Yes.
court commissioner was appointed on behalf of the DHR as per his proposal only. May I request the second page, commissioner's report on the second page, top end para, that the entire said commercial shops in front and rooms on backside and first floor have common walls to each other. Due to common walls on both sides, construction, demolition or any other work cannot be taken in the said property. If construction is taken place, the either sides of the walls will be affected and may cause damage to the building. So this is the observation which has been made.
That's
So
why I
this-
said, that's why I said, you do whatever you want to do with the first floor, give him this, give him the ground floor.
That is not practically possible because, my lord.
Yes. Where is the
And-
order?
Order is at annexure.
Page 13. Agreed with them. No, not 13. Where is this?
Page 90.
Page 90, my lords, annexure M.
990.
Since, my lord, page 92.
It starts from 90.
Agreed with the orders passed in I number 4 in execution case number 1110 of 2018 dated 5th February 2026 with the first additional senior civil judge and JMLC Hubli. You are the
Judgment debtors, my lords.
I am for the JDR.
JDR number? Only JDR?
No, my lords.
No. Altogether, 1, 2.
JDR number so and so.
One
Which
and
number? JDR number?
1A to 1D and
1A
2.
to D.
And 2.
And 2.
Yes.
Or before this court. A final decree was passed whereby all the parties to the suit were granted 1 by
1/8 share.
1/8.
1/8 shares. The petitioner has compromised with the seven
Remaining, except this.
except the respondent herein. He has
Respondent number
compromised
5.
with-
Number 5.
Huh?
Respondent number 5, decree holder who filed execution petition.
Except the decree holder with all other defendants, he has entered into a compromise.
They were the plaintiffs.
Huh?
Who compromised were the original plaintiffs, my lord.
Huh?
Those who compromised were the original plaintiffs.
He has compromised with other parties.
Other parties, yes.
Other parties.
That would suffice.
That will be
Except
more.
the respondent here. And now, 7 shares
Yes.
are to the petitioner and 1 share is to the respondent. Where is that? You said that which is unquestioned. Where is that?
Please, ma'am.
That allotment of shares and all, when was it?
Final decree, 17/12/2012, my lord.
17/7/2012.
17/7/2012.
17/7/2012.
17/7/2012. The properties were divided by meets and bounds, and a particular portion of the property on the first floor and on the ground
Ground floor.
was allotted to the petitioner,
That, my lords may say, portion marked as,
the respondent.
portion marked as EFIJ. If IJ.
EFIJ is allotted to the respondent. Now, after the compromise, the present IA, that is IA number 4, is filed by the petitioner herein under section 47 read with 151 CPC, seeking to determine the feasibility of enforcing the decree and handing over the portion of 1/8 share of the decree holder. And that came to be dismissed by order impugned.
5th February 2026.
That came to be dismissed by order impugned. While disputing the same, the court has observed that the decree holder cannot be compelled to submit a settlement when the subject debtors themselves are unwilling to offer any tangible or lawful alternative. The decree holder has acted with utmost bona fides throughout the proceedings. She made several reasonable offers to the judgment debtors, expressing her willingness to accept in lieu of her share. Despite such repeated and fair offers, the judgment debtors have shown complete unwillingness to part with any portion of the property. The evidence was led by both the parties, wherein it was stated that property may not be suitable for convenient partition. Such evidence pertains only to convenience, not to entitlement. In this case, the decree holder has extended every possible opportunity to the judgment debtors to to amicably resolve the matter. Despite repeated efforts, proposals, and reasonable offers made by the decree holder, the judgment debtors have failed to exhibit any genuine willingness to comply with the decree. The decree holder had even requested that her share may be allotted at any extremity of the suit scheduled property, either on the eastern side or on the western side, or at any corner portion, so as to avoid inconvenience to the judgment debtors. However, even such a minimal and reasonable request has not been accepted by the judgment debtors. The consistent refusal of the judgment debtors to allot even a marginal portion of the suit property clearly demonstrates their lack of bona fides. The conduct indicates an intention not to satisfy the decree, but to endlessly negotiate, but endlessly delay and frustrate the lawful rights of the decree holder. As the decree holders have not, as the judgment debtors have failed to come forward with a concrete proposal, the court had dismissed the IA. Learned counsel appearing on behalf of the judgment debtor submits that after the decree, when the petitioner before this court, after the compromise, the petitioner before this court is holding the 7 shares, and they have in fact offered a proposal in monetary terms, but the respondent is not acceding to that. He has relied on, where is that judgment he has relied on?
None copy. Judgment.
Yesterday he has.
This is the copy.
Taken. And he was relying on section
3 of the partition.
3 of the partition.
Yes, he was relying on section section 3 of the Act, but relying on the same, it is submitted that in these circumstances, where he is a majority shareholder, in the light of section 3, is entitled to have the remaining share. He has relied on the order passed by a coordinate bench of this court in WP number 5706 of 2021 dated 5th December 2025. He has relied on paragraph number
3, 8,
5, 6, 7,
and 8.
8, 10, and 11. Extract all those paragraphs. Then a counsel has also drawn the attention of this court to the Panchnama and submits that as per the report of the commission dated 22/10/2022, entire commercial shops in front rooms on backside and the first floor have common walls to each other. Due to common walls on both sides, construction, demolition, or any other work cannot be taken in the said property. If construction is taken place, the either sides of the wall will be affected and may cause damage to building. It is submitted that in these circumstances, the court has failed to, in the facts of this case, the court has failed to consider the application that's filed by the judgment debtor petitioner herein in its proper perspective. The court ought to have allowed the application as the property cannot be divided amicably. Next paragraph. Then counsel appearing for the respondent has submitted that the trial court, the executing court, has categorically observed that what are all the efforts that were made by the, take that, what are all the efforts that were made by the decree holder, and how the decree holder is amenable, amenable for amicable settlement. It is submitted that section 3 will come into play when the property cannot be.
Only in the final decree proceedings and not after drawing up the final decree.
The section 3 will come into picture only in the final decree proceedings. Final decree proceedings are concluded in the year 2012.
And not been challenged.
At this stage, that is not available to them. And that apart, the it is not the case that the property cannot be divided. He has relied on the judgment of the apex court in case of Vasudev
Dhanji Modi.
Dhanji Bhai Modi versus Rajabai Abdul Rahman, reported in 1970 Supreme Court, AR 1970 Supreme Court 1475, which paragraph?
6 and 7, my lords.
6 and
The
7.
executing court cannot go behind the decree, my lords. And
All settled law.
but my lord, to strengthen, my lord, and this one, my lord, paragraph number 63,
Then the next one is Periyammal, within brackets, read by LRs and others versus V. Rajamma and another, reported in AR online 2025 SC 172, paragraph
63, my lords.
63.
Yes, on internal page 27. On the proposition that, my lord, section 47 cannot be used to, my lord, seek adjudication of all these things.
With regard to the scope of section 47, he relied on paragraph number 63. Please extract that.
63, and it includes, my lord, the earlier judgment paragraphs.
Uh-huh.
That one paragraph, 63.
Which paragraph?
63, my lord. It includes, my lord, the extraction from the earlier judgment.
62 and 63 is
not
in
an
respect of
independent,
section 47.
That's not, apart from that,
63 includes, my lord, the extraction of judgment in Rahul Gandhi case, my lord.
anyhow, he
Right.
relied on section 6,
Yes.
paragraph number 63, extract. Relying on this, the court, it is submitted that the court had rightly rejected the application. Next part, having heard the counsels on either side, there is the material on record. There is no dispute about the fact that the petitioner before this, out of the 8 shares, the petitioner before this court, in view of the compromise, is holding 7 shares, and the decree holder, that is a respondent in herein, is having 1 share. The property is a commercial property, and it is, and they are the shops situated in first floor and ground floor of the building. According to the learned counsel for the petitioner has relied on section 3 of the act and also the report of the commissioner. Learned counsel has relied on the judgment of the apex court referred supra with regard to the scope of an application under 47, and that the executing court cannot go beyond the decree. No, even relying on section 6, section 3, this court has perused the photograph. It is not the case that that property cannot be divided and a share cannot be granted to the 1 share cannot be granted to the decree holder. In fact, the decree holder is acceptable to any part of the acceptable for his share on any side, but it appears that the decree holder, the judgment debtor, wants the entire building to himself. Section 3 of the Act does not give such a right to even to a majority shareholder. When the matter came up before this court yesterday, that is on so and so, considering all this court has referred the matter for mediation. From the submission of both the counsels, it appears that it also has not worked out, considering the fact that the decree holder cannot dictate the judgment debtor cannot dictate the terms just because he is having the major holding. And looking at the photographs, the court can quote on a bare perusal of the photograph show that a part of the building, any corner of the building, as for one share of the respondent can be accommodated, but for the best reasons known to the judgment debtor, is not inclined to give the same. However, his convenience is not the criteria, and considering the fact that in the year 2012, the final decree proceedings have attained finality, and also the fact that the property can be divided, this court do not do not find any reasons to interfere accordingly. Dismissed.
Grateful. Only one, my lord. Wherever my lords have said respondent, it may be respondent number 5, my lords.
Your name.
Only contesting is.
Contesting, that is
regarding
But it says
respondent 1 to
respondent, it
4
is a
given
decree
up.
holder. You are the only decree
only
holder.
decree holder, respondent number 5 in this.
4 are the earlier
Respondent
compromise.
number
5.
5 before this court.
Please.
In my petition also, I have written that 1 to 4 I am giving up. In my petition also, no claim against 1 to 4, that is already submitted in the petition also. trial court also they have not appeared because they have already entered.
The
They have compromised.
Respondent, because they have entered into
Compromise,
compromise.
1 to 4.
Respondent 1 to 4 have already entered into compromise when recording the contentions. Third, the respondent 1 to 4 have already entered into compromise with the petitioner. Hence, it is submitted that they are not necessary parties to this writ petition. Yeah.
Please, great.
Number 11. This is Jnanaya Swami.
Hearing for the petitioner, matter pertaining to recreation club, my lord, lordship judgment.
Matter pertaining to?
Recreation clubs. Set, covered by judgment of, please.
1 to 5, I take.
Yes, next, covered by judgment.
It's 1 to 5, I take notice.
Easy.
Yes, next one.
Seal number 12.
Appear for petition. The petitioner is husband of respondent. Plus, he has purchased the property in the name of wife way back in 2018, with his own in 2018. Plus, he has constructed a hotel, Haripriya International Hotel at Bagalkot. Plus, he has invested, the power of attorney was executed, general power of attorney, registered power of attorney was executed in favor of husband by the respondent. Plus, he has invested, he has paid the income tax, he has discharged the loan, entire loan. Now, she wanted to cancel the power of attorney after entire thing was discharged. She wanted to gain the possession of property. I was managing a hotel. She goes to the sub-registrar for cancellation of the deed. That sub-registrar refused it. Then she approached this honorable court for cancellation of the registered power of attorney. This honorable court in writ petition, as categorically said, it is coupled with interest. Unilaterally, you cannot cancel it. You have to approach the civil court. Plus, she went in appeal, writ appeal. Writ appeal also same fate, the respondent got, saying that it is coupled with interest. Then she files a suit for cancellation of the power of attorney. She don't make the suit property, hotel as a suit property. She has asked for a relief of cancellation of power of attorney. The trial court, she filed an application for injunction restraining the petitioner from interfering with the hotel business and for alienating the properties, alienating that property. The trial court, with a categorical finding that based on the judgment of this on court and writ appeal, hold it is coupled with interest and rejected the application. Injunction application was rejected. The appellate court grants the injunction.
Where is the GPA? What is that?
GPA I have not produced. This is GPA. I'm sorry, if lodge permit me. On the contrary, I have filed a suit. I got an injunction order.
See, what are the rights that are given to you by way of this
Yes,
GPA?
But initially it was mentioned, I have to pay the income tax. I have to
My
pay.
attorney has empowered
Yes.
all outstanding payable to the so and so income tax. Then borrow from time to time such loans to sell, exchange, surrender, lease or dispose of my said property which belongs to me in such manner.
I am not disposing of the property. It is my property. I have invested. I am not
So now
disposing.
the injunction that is sought is not to alienate. Let that be there.
She is restraining from interfering with the hotel business. Lordship can kindly see the IF which she
So
filed.
what is by virtue of this GPA?
Yes, sir. Plus, I took possession. I am managing the from right from 2018. I am managing the hotel.
Correct. But this GPA right to sell and all, where there is any consideration that is passed, it's a different aspect.
It's different.
But here there is no consideration.
No, consideration is there.
There is how much?
In the GPA, first para itself is there. Plus, she has to discharge the bank loan
My
of
husband,
more than 1
myself,
crore.
have purchased the said property under the register sale deed. Myself and my attorney associated with each other, and I have purchased the said property under the registered sale deed. And my attorney, is being my husband, has financially helped me while purchasing the said property. After purchasing the property, I have started hotel, restaurant and other allied business by constituting for running said business. I have raised huge loan. I am unable to repay the loan in time, thereby interest on the loan amount has been accumulated.
My entire loan, about 2 crores, my lords, are discharged. I am paying income tax.
Well, let's see the injunction, what is sought.
No, my lord.
No,
Yes.
wife and husband, they're not staying together.
No, now, my lords, because of this dispute. Plus, the trial court, my lords, with elaborate reasons, dismissed the application. I have got an injunction order against them in the Bagalkot court, that is prior to their injunction. In spite of that, bringing to
What
notice.
is the suit filed by you?
Suit, my lords, suit property is, my lords, hotel property. I sought for, my lords, restraining them from interfering with the hotel business. That is, IA is allowed, is intact now. They have filed MA, there is no stay order. That during penance.
Then if the suit, if the injunction suit is filed there, this is a declaration, but what is this cancellation?
Cancellation of power of attorney.
Which court it is?
It is Ramdur court they have filed, but property is situated in Bagalkot. That contention is also.
Jurisdiction will come to that court.
Yes, no, Ramdurga court has no jurisdiction, that is also contention raised. Ramdurga court rejects the application, they went in appeal, appeal is allowed. Miscellaneous appeal, though I have taken contention, Ramdur court has no jurisdiction.
Your suit and your injunction is first.
Yes, ma'am.
When she filed the second suit, was this mentioned she was contesting the suit?
It was mentioned, my lords, and in my suit also I mentioned that she has filed a suit for, my lords, cancellation of power of attorney. That is reflected in the order, in my injunction order. Kindly turn to Annex G.
And then that means their suit is first.
No, my suit is
No,
first.
if your suit is first, why would you write it in the plaint that so and so suit is filed?
No, not in plaint, in order, my lords, they have mentioned. In the order I mentioned.
Yours.
Yes, in my injunction, in the order they have mentioned that she has filed a suit, but at that point of time there was no injunction order, or application was not heard. Ultimately,
What will be the effect of these two orders now?
no, plus I got an injunction order. The appellate court says the power of attorney is cancelled unilaterally because she has cancelled it by virtue of issuing notification, publication.
Public notice.
Which is contrary to the finding given by in writ petition and writ appeal also. They say that it is not coupled with interest.
So if it is cancelled, why should what is there left to that court to decide now?
The appellate court says, it's wrongly, appellate court says.
I'm saying if appellate court is giving a finding that is already cancelled, then what is to be decided
That,
by the
nothing
trial
can
court?
be decided in suit.
Yes, what you
That is
say?
the finding. Unless I leave the lordship permit me, I'll take your lordship to appellate court order, which is directly
I understood. What
contrary to the high court order.
Lord, may I request to my lord may consider ink page number 31, the plaint our.
Before going into that, actually you can clarify to the court.
Please.
One injunction by one court, which is still staring at you.
My lord,
Now you file another suit in some other court and you get an injunction.
one submission. This OS 62/25, wherein we have not received any notice. And we have not having knowledge about this. Even they have not stated before the first appellate court. And secondly, my lord, the
Notice is not served in his suit to you?
no, my lord. Itra naval.
When is the suit filed? He says against an interlocutory interim order, you have already filed an appeal. Miscellaneous appeal is pending.
Regarding jurisdiction, my lord, before the Ramdur court,
If one by one, whatever I am asking, if you clarify, that would be easy to the court. He has filed a suit, he got an injunction. Against that injunction, you have filed an appeal. Your appeal is pending. It is correct or not?
we have to ascertain, my lord. because-
That's what he's saying, that appeal is pending.
I mentioned the appeal number also in the petition.
It will be taken on
So-
Monday, my lord. Will be
Yes.
taken on Monday.
Yes. This matter on Monday.
Let there be interim order, my lords. I will not alienate the property, but
Till such
they
time-
should not interfere, my lords, with that.
Till such, this is matter on Monday till such time. The respondent shall not interfere with the petitioner's possession in respect of the suit schedule property.
Right.
Yes, next.
Still number 30. Prasad Patil.
Therefore, the petitioners, my lord, the matter pertaining to the, the petitioners have challenged the impugned possession notice, my lord, produced at annexure J, my lord. Initially, my lord, the petitioner's father, who obtained a home loan, my lords, from the respond number 4 bank, my lords, of rupees 5 lakhs, my lords. Now, all of a sudden, my lords, the respond number 4 through respond number 2, my lords, got issued the possession notice, my lords, which is scheduled to be on 26th of this month, my lords. Not the outstanding balance which they are showing, my lords, 9,49,000.
When the father died,
My lords, he died in the month of May
Then how come these proceedings were initiated without what the proceedings that are initiated
Please.
against the deceased father? No, they get abated against him. No, that if at all you want, you have to take fresh get instructions.
Yes.
It is
My lords,
submitted with
Annexure
the
J is the only notice as issued by the, my lords, the Tahsil, my lords, the Deputy, my lords, Assistant Commissioner, my lords, under section 14 of the Act, and in the
of the
14 of the Secretariation Act, my lords, Surface Act.
no, which is the bank?
My lords, it is a private bank, my lords, the Ivadnya Sahkari Bank.
Even against a private bank also, High Court.
Please, my lords, but all of a sudden, my lords, through respondent number 2, my lords.
It is submitted that the loan is obtained by the father of the petitioner who died in the month of
My lords, 5/5/2025.
5/5/2025. Now, the proceedings which were initiated earlier are continued against the legal head.
Please, my lords.
It is submitted that the proceedings have to be initiated afresh, but they cannot continue the same on the legal heads. Considering the same, they shall be stay of all further proceedings pursuant to so and so. Notice to all the respondents. You take notice to whom?
I take
1 to
notice,
3,
my
my
lords.
lords.
Huh?
1 to 3.
What I am not able to understand is why a Tehsildar is a party.
My lords, because of they have directed the Tahsildar to take the possession of the property, my lords. That is in the input
The
notice.
Securitization Act, what is the Tehsildar doing?
Illegal notice.
Please, my lords. Yeah. Yes, ma'am. Tahsildar has directed to take.
Then 1 to 3.
Yes,
AGA takes notice.
please.
Yes.
Please note. Seal number 14. Srinivas Naik.
Lord, I am defendant number 3 in the suit. Lord, I filed application under section 11 of CPC. Lord, containing that Lord suit is hit by res judicata, it cannot be tried. Court observes that Lord suit is Lord there are undisputedly suit Lord there was earlier suit in which compromise petition was filed, and Lord court observes since Lord it was by collusion, therefore Lord the present suit is maintainable. Kindly see page 46. Lord.
40.
46.
Yes.
Para 11. Lord.
Please read.
May I read? Further, it is undisputed fact that present defendant number 1 was filed OS number so and so on the file of this court against the defendant number 2 to 4 herein for relief for partition and separate position over the suit scheduled properties. Further, it is undisputed fact that the properties were subject matter of that suit and the suit scheduled properties herein are one and the same. Further, it is undisputed fact that the said suit came to be disposed of by way of compromise decree. Further, it is undisputed fact that the suit scheduled properties are ancestral properties of plaintiff number 1 and defendant number 1 to 4 herein. Further, it is not the case of defendants that the suit scheduled properties are self-accord properties of defendants from other defendants herein. Further, herein, on prima facie, on looking of the to pleadings of the parties and the document of the parties, it is admitted fact that defendant 1 to 4 are the residing under one roof. Further, it is undisputed fact that there is a difference of opinion.
Plaintiff was a party to the earlier suit?
Plaintiff father was the party to the suit. Because plaintiff father is a defendant number 1 in the present suit. Defendant number 1 to 4 are the Lord family members. There was already Lord suit filed by the Lord defendant number 1 himself.
What is this finding? Defendant number 1 to 4 were colluded with each other.
That's
filed
what,
that
Lord.
suit and get the compromise decree.
Yes.
Since at the time of filing of the suit, plaintiff herein were not living with the defendant number 1.
Now, how can Lord, even if that has to be done, Lord, they have to claim the share of the defendant number 1, not against all the Lord plaintiff defendant.
Present petition is filed agreed with the order dated 3rd November 2025 in I number 2, where an application is filed under section 11 of the CPC saying that the suit is barred by res judicata, as earlier a suit for partition was filed and a compromise decree was entered, and the present suit is not maintainable. They are not even saying that that compromise is not binding.
Not pending.
It is and the court had dismissed the application saying that the father of the plaintiff was the party, but plaintiffs are not the parties to the suit, and by collusion the decree is obtained. Land counsel submits that it is not even the case of the plaintiff that the said decree is not binding on them. and the same has to be set aside. Say, there no declaration of such nature is sought. But the court had dismissed the application contrary to the settled law. Considering the same, there shall be stay of all further proceeding. Notice to the respondent, hand summons, memo shall be filed by 18th of March, or else the stay granted by this court stands vacated.
Great.
Yes, next, seal number 15. SP Kulkarni.
For petitioner, my lords. But in this case, my lords, petitioner purchased the timber through auction, my lords, from the deputy conservator forest officer, my lords.
This tax one.
Please, my lords.
Yes, same similar order, forest tax. 12%. Yes, next, 16.
AG. Seal number 16.
Lords,
Dinesh Kulkarni.
suit for partition and separate possession, my lords. I have filed amendment of plaint, my lords. Same came to be rejected, my lords. Hence this appeal, my lords.
When was the suit?
In the suit was of 2024, my lords.
Suit is 24.
Suit is of 24, my lords.
What is the suit for?
Suit for partition and separate possession, my lords.
What is the amendment now?
Only with respect to the boundaries of the suit property, my lords. I have sought amendment in the.
Let's see that order.
Please, my lords. Order is at page number 61, my lords. The trial court on observation that to fill up the lacuna, I have filed the application, come up with the application, my lords.
No, when the case is posted, I think it is renumbered as 24.
No, my lords. The earlier suit was between my brothers and other branch of my father, my lords.
Case is posted for judgment.
Please, my lords.
Why did you file this application at the time of judgment?
I have filed, my lords, before the matter was posted for argument, my lords, and after hearing the arguments, I have filed advancement application and I have filed application for amendment of plan.
File at that point of time.
Sorry?
The trial has commenced.
Please, my lords.
Trial is completed.
Please, my lords.
Arguments are concluded.
Please, my lords.
When the matter is posted for judgment, why should you file this application and why it should be allowed?
My lords, at the, while I was preparing for the argument.
Affidavit. Come to the affidavit.
Please,
File
my
in
lords.
support of it.
IA is at page number 54, my lords.
Yes, read it.
I shall read the proposed amendment in IA, my lords.
What is this? I have filed the top noted suit against the defendant seeking partition and separate portion. The top noted case is fixed today for argument. At the time of preparing for argument, I noticed that knowledge the above said fact is not incorporated. That's why you will incorporate.
My lords, only thing is, I have not mentioned the boundaries properly, my lords. Only to that extent I have filed the amendment, my lords.
It is too late in the day.
My lords, the other thing is, the issues itself is not framed in the suit, my
Only
lords.
thing the court can is, I'm not dismissing it. Notice to respondent.
My lords, issues are not framed in the suit,
If
my
you
lords.
want, if you argue anything, I'll dismiss it. Notice to the respondent.
Please, my lords.
Seal number 17. Seal
My
number
lord, I am appealing for the petitioner, my lord. I am seeking mandamus for payment of compensation, my lord. My lord, the petitioner is owner of 3 guntas of land.
To initiate land acquisition proceedings in a time-bound manner for compensation. To pay compensation for the entire extent of so and so. Who are the respondents?
My lord, 3
First one is the
petitioners, they
state.
are laying the line,
Second is
110 kV line above my property.
Karnataka Port Transmission Corporation, KPTCL.
Yes. My lords, I take notice for R1.
I'll serve a copy.
I take notice for R1.
AGA takes notice for R1
Other
and 2 who appears?
BS Comte appears.
So and so for 2.
2 to 4.
2
All
to 4,
2 to
so
4
and so.
of petitioner.
Counsel for the petitions is all show the copy of the writ petition on the counsel for the respondent. Let's this matter on 5th of March.
Please.
Yes. 18.
Till number 18.
The petitioner has given, petitioner owns a land in Gokul Road, Hubli, madam. It's a prime commercial area. It's an open land. He had obtained connection, electricity connection in the year 2024. On 16 February, the HESCOM department.
Notice dated issued by the respondent.
Yes, madam.
Letter dated issued by the respondent.
Yes, 16/2.
restraining the respondent, cutting the electricity connection of the petitioner's meter.
In the notice, my lord, which is produced at Annexure C, page number 27.
The executive engineer has come.
My lord, in the notice,
How can you file an writ petition against assistant executive engineer ESCOM? ESCOM is represented by whom? Assistant executive engineer.
he is the authority which has issued the notice, my lord. Here, B.S. Compressor is appearing for a. That is how it is practiced here, my lord. Not,
How these writ petitions are numbered, I'm not able to understand. No. Writ is filed against assistant executive engineer ESCOM only.
notice was issued by that authority, my lord.
Land
Notice,
Council shall amend the cause title and add the necessary parties.
my lord,
This is
my lord,
matter.
one submission, my lord, one submission. Petition was filed to not cut the electricity, my lord. Petition is filed not to cut the electricity. Now, in the notice, they have said that a third party has issued complaint against me that I have obtained the connection on by submitting false documents, and they have issued me.
Called you, they asked you to come to the office. They wanted a explanation from you.
No, my lord, that is the issue. Within 2 days, they have cut my electricity. On 16th, they issue notice. On 18th, they tell me through the notice that they will cut off the electricity on the 18th of this month.
Today is what?
Today is 19th, my lord. Yesterday, somehow they have managed, and the shop owners and the owner of the product,
Yes, for the ESCOM.
Compressor, B.S. Compressor.
Call him. Call him. Yes.
Fast. Seal number 19.
Please, my lord, this petition is seeking for Mandamus, seeking to the police
Recreation.
authorities to seeking the permission to conduct the indoor sports creations club, my lord.
It's case of recreation club.
Petitioner and direct the respondent not to institution law license for playing skill game. This is another form of the same writ petition.
Yes.
Yeah, same.
Or the same form of the writ petition.
Yes.
No, it is the same form or the another form of prayer.
No, same formulas. Take notice for R1 to R3.
Yes, 20.
To office of action is there. Permit me to comply that. Office of action is there, my lord. Please. So,
Yes.
Seal number 20. Ganesh Raibagi. Ganesh Raibagi, seal number 20.
No representation. List this matter on 11th of March. Yes, 21.
Orders matter, seal number 21.
My lords, already matter is settled before the Lok Adalat. Kindly permit us to withdraw the petition. Memo.
A memo is filed stating that the matter is settled before the Lok Adalat. Since the petitioner wants to withdraw the petition, accordingly dismissed as withdrawn. Yes, 22. Give the extension of time. Letter is there in the next one. Next one, 22.
Seal number 22.
Appear for the petitioner, my lords.
Earlier, an order was passed by this court to dispose of OS number 140 of 2003 within a period of 6 months. Now a letter is addressed stating several facts. As there was an interim application, the court could not dispose of the matter within the time granted. And now the matter is posted for cross-examination of PW1 and sought for another 6 months' time. Finally, 6 months' time is granted. It is made clear that within the 6 months, the suit shall be dismissed. No further extension of time. Yes, 23.
Number 23.
Give that.
I respondent filed an application for matters to withdraw the deposited amount. In this case.
No, the petition is filed. This is a memo for withdrawal of amount.
Yes, ma'am.
Where is the petitioner? What is this GMFC?
Yes, ma'am.
Yes.
The husband is dead, ma'am.
Memo of withdrawal?
Please.
Where is the memo?
Memo is, my lord,
The memo is
9126.
by the respondent seeking to withdraw the amount deposited by the petitioner,
25,000 only.
an amount of rupees 25,000 with accrued interest, no representation on behalf of the petitioner.
This is disposed of matters. This matter is disposed of.
Then,
Then I permit to withdraw the amount. This is kept in the.
where is that order?
Yes, my lord. I will, I annexed the. next
Earlier,
page.
this court has filed this court has disposed of the petition by order dated 21st October
October, yes.
2024.
Yes.
Basing on the submission made by the petitioner that since the MC is disposed of, the writ petition has become infructuous, and accordingly this petition, the writ petition is dismissed as infructuous. Now the IA is filed with the respondent, submits that during the subsistence of the writ petition, an amount of rupees 25,000 was deposited by the
Husband
petitioner.
before the Sunday.
The petitioner, hence the respondent were permitted to withdraw. No objections are filed by the petitioner. Accordingly, the respondent is permitted to withdraw the amount of 25,000 with accrued interest.
Much of.
Yes.
Bill number 24.
In this case, I filed my lord's memo for disposal of the petition.
Who filed?
I filed my lords.
What is this?
This is my lords, they have communicated to our office saying that they will withdraw the my lord's petition. And that is my.
Have any further claims, my lords?
You don't have?
A claim against the respondents,
You want to withdraw?
please.
Where is the memo?
I only filed.
Memo for
State
this.
has filed the memo.
We had issued a communication to the respondent saying that we'll withdraw this.
No. Writ petition is filed by him.
Yes, ma'am.
If they want to withdraw, they should file the withdrawal memo.
My lords,
How
the-
can you file a
my
memo?
document which I have produced at my lords ink page number 2, that is in Canada.
The above has been filed with seeking the release.
Yes, ma'am. That he has intimated on my lords of 1/4/2025, saying that he will withdraw the petition.
He will withdraw
Yes,
then.
let him.
I'll file the memo for withdrawal.
Let's just mark on Wednesday for filing the withdrawal memo.
Please.
Don't file those kind of this thing because you can't. If he wants to withdraw, he will withdraw.
Yes.
How can the state say that he has communicated to us, so memo of disposal to withdraw the petition?
My lords, they are also not disputing that the claims are.
Can't file.
Yes, yes.
Technically, you can't file like that.
Please, please.
Please.
Yes.
24. Still number 25. Do you sum up?
Kind of posted on next week, my lord. Next week it may kind of.
My lord, since there is a stay, my lordship, the matter was supposed to be listed tomorrow in the trial court, my lord. Since there is a stay, they are unnecessarily, they are prolonging the matter, my lord. They have filed the IA for recalling of cross-examination of plaintiff, my
What
lord.
is the suit for?
Suit for partition, my lord. Suit
Which
for
year is
partition
the
is separate position.
Which year is the suit?
2021, my
plaintiff.
lordship. The suit was filed on
What
23/12/2021.
is the impugned order?
Impugned order, the further proceedings in the suit is stayed.
Impugned order.
Impugned order is
Impugned
at
order
page
is,
number 28.
28.
Order dated 19/3/2024.
Defendant present, advocate for so and so, heard argument so and so. File suits for partition against the defendant. Application filed. Paid and incomplete and all these are signed or not justified. What is IA number 16 and 17?
The recalling application, my lord.
Recalling
They have
app-
filed an application for recalling of plaintiff, my lord, for cross-examination. That has been rejected, my lordship. When the matter was posted, that time they remained absent and sufficient opportunity was accorded to the defendant number 1 and 2. They failed to cross-examine the plaintiff. Now they have filed this application, my lord. That has been rejected.
No, had that been allowed 2 years' time, you would have saved.
But my lord, in the application,
You lost 2 years' time. We'll say within a time-bound manner, within so and so, they should complete the cross-examination of, further cross-examination of PW1.
but my lord, kindly appreciate, my lord, in the application, they have not specifically stated whom they wanted to cross-examine, my lord. There are two plaintiffs,
PW1, my lord.
but that has not come forthcoming in.
Clarify that.
Please, that may.
The writ petition is fine.
And also, another application was filed because they have not given opportunity to give evidence of the difference 1 and 2 also. Difference number 1.
Where are
It is,
your
take,
applications?
it is taken as
My lord, since
Defense
that
evidence.
the matter was posted for the evidence, my lordship, they remained absent and sufficient opportunity was accorded.
That is
They
the-
failed to,
No, the defendant has not reduced evidence.
yes, ma'am.
So let them do both. We will grant the maximum time of how much? How much time?
As your lordship,
The present petition is filed, agreed with the orders passed on I number 16 and 17, dated 19/3/2024, whereby the court had dismissed both the applications. The petitioner before this court is the defendant.
defendant 1 and 2,
Defendant 1 and 2. The respondent herein has filed a suit for
partition.
partition and separate portion. In that, the defendant, as he has not cross-examined PW1 and also has not adduced any evidence on his behalf. Both the evidence of the same was closed, was taken as nil. At that point of time, the sign number 17 and 16 and 17 are filed. 16 is filed to recall PW1 for cross-examination, and IN number 17 is filed to adduce evidence of the defendants.
Please.
Correct?
Defense evidence.
Defendants. The court had dismissed the same. Observing that order sheet is perused, already sufficient opportunities has been granted since 5/3/24, hence prayer is rejected and evidence of defendant number 2 is taken as nil. 1 and 2 is taken as nil. When counsel appearing for the petitioner submits that this is a suit for partition, unless and until the parties are examined and they're given an opportunity to lead to adduce the evidence, there would not be any end to the litigation and it would not serve the purpose. And in the substantial interest of all the parties, they may be permitted to, the applications may be allowed in a time-bound manner. They'll be completing the same. When counsel appearing for the respondent plaintiff submits that in spite of giving repeated opportunities, the defendants have not adduced the evidence, nor they have cross-examined the plaintiff, and the court had rightly dismissed the application. When they say they want to cross-examine, they don't even specifically say whom they want to. And on all these reasons, court had rightly dismissed and rightly rejected the petition, and there are no grounds to interfere. The suit, having heard so and so, the suit is of the year 2021. An interim order is granted by a coordinate bench of this court on 26/3/2024. For last more than 2 years, the matter is pending before this court. Considering the fact that this is a suit for partition, though there are lapses on the part of the defendant, giving him a final opportunity, this court deems it appropriate to pass a following order. The order passed by the court in so and so is set aside, and I number 16 and 17 are allowed. The petitioner shall cross-examine PW1, and also the petitioner shall be permitted to adduce evidence. Petitioners, that is DW1 and DW2, and they shall be permitted to cross-examine the PW1.
Yeah.
And also the plaintiffs can cross-examine the defendants. All this exercise shall be completed within a period of 15 days.
Please.
15 days. Within a period of 15 days. If the defendant does not cooperate with the same, and if he asks for any adjournment, the trial court shall not grant. Accordingly, disposed of. With costs of rupees 2,000 to be paid to the respondent.
Please.
Yes.
Grateful.
Seal number 26.
Just after service of notice.
My lord.
This petition is filed by JDR number 1.
Huh?
JDR number 1 has filed this petition, judgment debtor, wherein the order of the
Notice to R2 not necessary?
R2
It's required,
is
my lord.
also a judgment of debtor number 2. For time being, we dispense with it.
my lord, what happened, my lord, in this case, my lord, last occasion it was listed, my lord, but today it's also listed, but my name is wrongly shown, my lord. Last occasion, this honorable court has directed the registry to show the correct name of the respondent number 1, my lord. Today is also wrongly shown in the cause list, my lord.
Councils.
Write your name.
In the order sheet is correctly stated, my lord. KALWAD.
And my lord, one submission, my lord.
Name of the respondent shall be correctly.
Date may be
correctly
fixed,
shown
my
in the
lord.
causes. Today also, the name is not correctly shown, the registry shall print the correct name.
Well-
But the memo is filed seeking dispensation of notice to R2, dispense with at the risk of appellant. This is
Okay.
matter on Monday.
Please,
Yes,
please.
27.
Please.
Still number 27, Vishwanath Bhatt, Jay Shetty.
Please, my lords. The petitioner is studying in the 7th respondent college, my lordship. On the basis of the birth certificate, as per annexure A, the name of the father is changed, directing the respondent number 1 to 6.
To cancel the admission of the petitioner and not to disturb the academic year of the petitioner, the respondent 7 college. Who is respondent number 7?
7 is the present studying the petitioner, my lords. Hotel management course before the 7th respondent.
Principal Milagres College of Mangalore.
Yes, in the ID proof and PAN card, Aadhaar card, his name is differs in the school certificates, respondent number 1 to 6, my lordship. Prajwal Govind Patkar and Prajwal D. D'Souza. As per the adoption deed, Prajwal Govind Patkar is name is changed
What
in
are
the
all
ID
these
card.
are all private parties. How can the writ petition lie against them? These are all private colleges. You are not aggrieved by any action of the government.
I'll give a representation to the concerned school, my lordship, but they are not changed.
How can we issue a writ of mandamus to a school?
On the basis of the birth certificate, change
Please
the name in the
understand
school
that
certificate.
We can't do like that. Is this matter in the month of April?
Respondent number 2 is already PF is paid yesterday. Respondent number 2 is concerned, PF is paid
Sir,
yesterday.
I'm not, if I hear, I have to dismiss it. That's why I'm adjourning it. April. Yes, 28.
28, Ma'am Patil.
Yes, extension of time. The letter is addressed by the first additional civil judge and JMFC seeking extension of time. This court on 4th December 2025 has passed an order where the court requested to conclude the contempt petition within an outer limit of 4 weeks, stating various reasons. Requesting 2 months' time accordingly. The 2 months' time is granted, and the court shall conclude the proceedings within 2 months without seeking further extension. Yes, next.
Nice, number 29. Nandu, Nandu.
It is dismissed for non-prosecution. 48 days is delay, my lord. Filing recalling application, my lord. Non-compliance of 2 objections. Writ for mandamus, my lord. Writ for mandamus, my lord. We have constructed, we have taken the tender, my lord, completed the work, my lord.
First of all, you have not completed the office
Please,
objections.
I'll complete.
Pending consideration of the IA, the petitioner shall comply with the office objections within 2 days. Once the office objections are complied with, this is matter.
Please, ma'am.
Yes, 30.
Still number 30. Number Tarlatur. Rajkumar Dhol.
Please.
Yes.
My lord, see the first case, for the respondent, my lord, there is a delay of 2,452 days of time.
It's filed by the claimant.
It's filed by the claimant, my lord. It's a normal delay.
File objection to the not delay.
On condition, we'll condone.
My lord, I'm for the respondent, but he should have been here.
Then we'll condone on condition.
In case of any enhancement, the claimant will be not entitled for any interest.
IA number 1 of
2,400, 2,452 days
I
delay.
can see that. IA number 1 of 2025 is filed to condone the delay of 2,452 days in filing the petition for the reasons, then counsel appearing with respondent as opposed to same for the reasons stated. The delay is condoned on condition that they will not be entitled for interest for the delayed period.
Right.
Post this matter called, TCR is already there, yes. This is matter for final hearing. 31,
31. Seal number 31.
I number 2 of 25 is filed. to
I am
condone
filed the
delay.
appellant, my lord.
39 days. Accordingly, delay is condoned. Admit post final hearing, TCR. S32.
Seal number 32. Sunil S. Desai.
We'll serve the copy, my lords. We have filed two IAs, my lords.
Yes.
One is for, my lords, the impleading of proposed respondent number 6 and 7. And we'll serve the copy, my lords. And we have also filed for IA for vacating of stay. My lords, we'll serve the copy today, my lords.
You're served today.
No, my lords, we'll serve it, my lords, today.
You're serving.
Please.
Yes, then counsel for the respondent shows the copies of the IA on the counsel for the petition.
Date
This is
may
matter in the month of March.
My lords, interim order may kindly be extended. Interim order may kindly be extended.
Interim order earlier granted is extended. 30,
Submission.
33.
On submission.
33.
That's on submission in the case. Number 33.
Huh?
That's the tender matter of my lord, sand has been halted for because of the tender of the my lord, the sand. Tungabhadra River has been stayed because of the
There is urgency in this.
some emergencies.
List on 3rd of March.
Yes.
Oh, please.
Seal number 33. Ravindra R. Mane.
My lord, case of injury arising out of Employees Commission Act, Compensation Act, my lord. The only ground raised is that the driver, who is the claimant, my lord, was not duly licensed.
It is submitted that the driver is not having a valid driving license. And in spite of the same, the court had granted the compensation. Accordingly, the compensation, it is submitted that the entire amount is deposited. Hence, there shall be stay of all further proceedings. Notice to the respondents. Yes, 34.
Please, my lord.
34.
My lord, hand delivery may kindly be. Hand delivery.
In which case? Yes, hand delivery. Yes, 34.
The claimant's appeal for seeking enhancement, my lords.
Yes,
34, my lords. The claimant's appeal for seeking enhancement.
Notice.
Lords, I seek dispensation of notice to respondent number 1, 5 and 6. my lords.
1 and
1, 5 and 6.
take that. So and so dispense with the risk of appellant. Notice to the respondents. 35.
Lords,
Seal number 35.
I am seeking dispensation of notice to respondent number 1, lords.
Notice dispensation to 1, notice to the respondent. Yes, next 36.
Lord, I appear for the applicant in this matter. Lord,
Yes.
this is that matter where your lordship had passed an order directing the labor court to consider the issue of maintainability of these individual VRS petitions. Voluntary retirement scheme, my lord. If there's a small mistake, my lord, which is arisen, if I may humbly request, my lord, to kindly see that. Your lordship may kindly see para 2, my lord, of the order.
Yes,
Para 2.
yes.
Page 2, about 4 lines after the paragraph. In the month of April 25, petitioner company decided to close the operations at Dharwad due to heavy utilization, underutilization. My lord? My lord,
Page
the-
number 3.
Page number 2 and 3, my lord, yes. Page number 2 at the bottom of the page. In the
month of April 2025.
Yes, my lord. That actually is December 2025. We decided to
In the
close
month of September.
December.
December 2025.
Yes, my lord. Because we offered the VRS, my lord, and then because of the VRS being successful, we had to close down the operations.
Decided to close the operations at Dharwad unit due to heavy underutilization and a challenging business on 16/4. No, I think it can't be December 2024.
No. December. What happened, my lord, was first we offered VRS. Because the VRS succeeded, we, my lord, then
I think
had to
all
close down the
these facts are from your pleadings.
No, my lord, in the petition we haven't said that, my lord. There's a small mistake in the list.
No, let us see.
Yes.
No, these facts are from your pleadings. Let us see what your pleadings say.
Can I request, my lord, to kindly see? The para 12, my lord.
1 minute, 1 minute.
Para 8, my lord. Para
This is
8.
what you said. It is, you said, in and around April 2025, the petitioner decided to close operations at the Dharwad
That's-
unit.
my lord, yes, my lord. In the list of dates, there's a mistake, but my lord, in the petition, my lord, there's no mistake. If you lordship kindly see para 8.
Para 8.
8. At
On
page 12.
April 16, 2025, intimated all the employees at Dharwad to publication and offered to
offer
initiate
to
a voluntary. So it should be corrected as April 16, 2025.
Yes, my lord. April 16, 2025, not to close the operations. We didn't decide to close the operations. We decided to offer employees, my lord, the benefit of one-time settlement. Maybe your lordships can consider deleting that line, my lord.
Huh?
If your
That
lordships
we have
can-
deleted.
That one line can be deleted. In the month of April 25, petitioner company decided to close operations.
Yes.
And straightway on 16/4, my lord,
Yes, that in the month of April till an environment, till that I will delete.
yes, ma'am.
The petition company intimated to all, on 16/4/2025,
That will
company
continue.
intimated to all the employees.
That will
That's the only
continue.
thing.
That will continue. Everything else will continue. Only that one line, ma'am.
Yes.
I'm-
Then an IA is filed seeking correction of the judgment. It is stated that in paragraph number 2, bottom, in the month of April 2025, the petition company decided to close the operations at Dharwad unit due to heavy utilization, underutilization, and a challenging business environment. This the date that is mentioned in that is not correct. Accordingly, as far as this sentence shall be deleted and the corrected copy shall be uploaded.
I'm great. Very great.
Admission matter, seal number 37. Kulkarni Dinesh. Dinesh and Kulkarni.
Yes, sir. Suit for declaration and injunction, my lords. I have filed interim application of temporary injunction, my lords. That came to be rejected, my lords. On the ground that I have not established my title, my lords.
Let's go to the order. Where is
Please,
the order?
at observation at page number 16, my lords.
Let's read. Let's read from the reasoning part.
Please. At paragraph number 7, my lords.
Read.
These points are interconnected to each other, hence I would like to discuss these points together at one stretch to avoid repetition of facts. Plaintiff has filed the suit against the defendant for relief of declaration and consequential relief of permanent injunction, and also maintain the application under Order 39, Rule 1 and 2 of CPC for seeking interim order of TI against the defendant, restraining them from interfering or trespassing over the suit schedule mentioned property. Further submits that the suit schedule property, originally government Annadana land, the said property was granted in favor of his brother and father of the plaintiff number 1. After demise of father of plaintiff number 1, mutation was effected in favor of plaintiff number 1 on inheritance. The defendant are not the absolute owners of the suit schedule property, and they are illegally trying to grab the suit schedule property by causing obstruction to the peaceful possession and enjoyment of the plaintiff, my lord. To establish the case, the plaintiffs have produced documents, namely RTC extracts for the year 2023-24, genealogical.
Right to Information Act, the Tehsildar has issued saying that those documents are not available with them.
Please, my lords. My lords,
And how to believe that document?
my lords, the document is of the year 96, 91 and 92, my lords. That might be destroyed, my lords. I have filed, there are multiple
Revenue
proceedings.
records won't be destroyed.
My lords, there are multiple proceedings earlier, my lords. I have filed, they have challenged the entry in before the AC and DC, my lords. Same came to be dismissed. In the writ petition, they have challenged the same, my lords. Writ petition was also dismissed, my lords.
Petitioners have submitted the Saguvali Chitti of 8/11/1993.
Please, my lords. I have produced that along with my memo, my lords. I have produced a memo for production of documents, my lords. It is at page number 15, my lords. My father's name is reflecting in the said grant certificate, my lords.
No, this is not a negative order. It is only in an order of remand. What happened in the order of remand? Page number 7 of your documents.
Please, my lords.
Order of remand you have filed.
Please,
After
my
the
lords.
remand, what has happened?
After the remand, also the plaintiff's names were remained, my lords.
Where is that?
My lords, I have produced the RTC extract, my lords, and also mutation entry I have produced, my lords. At page number 17, mutation register, my lords. Mutation number 2 of 9697, my lords. Page number 17 of my memo, my lords.
Why are these documents not produced before the court?
I have produced, my lords. All the AC orders, DC orders, I have produced, my lords. That is observed in the paragraph 8 of the order, my lords. I have produced all the documents, my lords. But that were the same were not considered by the trial court, my lords.
But there is no document to show that Ningana Gowda Basappa and Basave Gowda are one and the same.
My lords, in all the documents, there is a Basave Gowda is only in the genealogical tree, my lords. Other than that, in all the documents, it is Basan Gowda only, my lords. My father is Basan Gowda, my lords.
Let other side come, we will see. Notice to the respondent. Petition is permitted to take out hand summons and file a memo. Once memo is filed, list the matter. Yes, 39.
Yes.
Date urgency number 39.
My lords, the impugned order at page number 13, my lord, the petitioners filed application I number 23 and order 16 rule 1 and 2 for direction to
Appear with the respondent.
Vishwanath K. Bhatt.
Any urgency in this?
This is not.
This is the matter in the month of
My lord,
March.
interim order.
Interim order earlier granted is extended. Next 40.
Seal number 40. Malikan Swami B. Hiremat. Sanpatiyam Bhatt.
This is a matter where he is saying that direct petition can be allowed.
Yes, the reason is this, my lord. The suit was decreed. Challenging that defendant number 1 is in appeal. Instead of filing an appeal before the district court, because the pecuniary jurisdiction lies to the district court, he had approached this honorable court. The appeal was returned to be presented before the appropriate court. He presented it within the time stipulated by this honorable court. Despite that being so, there was an interim order granted saying the operation and execution of the trial court judgment. Thereafter, the respondents therein entered appearance. Now, the trial court dismisses IA for stay, holding that the appeal is barred by limitation. That order is called in question. In fact, that entire period of millets is also excluded by the Supreme Court because it was during that COVID, this appeal was filed. Though it takes note of that. Millets, the impugned order, millets will get it, page 61, millets. Order on IA number 1. After the appeal was filed, initially interim order was granted.
Page number?
Page 61 is the operation, the order millets on order IA number 1.
61 or 63, yes.
It starts at, the reason starts at 63.
Only on this ground.
Application is dismissed and this finding that appeal is barred by limitation has to be set aside. For the simple reason, if you lordship sees the order passed by this honorable court at page 36 while returning my appeal. Page 36 minutes. It started at 34. The judgment is at page 36.
From when it is pending before this court, when did you filed appeal in time before this
The
court?
appeal was in time. It was returned minutes to be presented before the proper court and 6 weeks was granted. In fact, I had filed it within 4 weeks only minutes from the date of receipt.
Yes, please come. Where is that order you said of our court?
Of this honorable court, my lords will get it at page number 36.
I've seen. Agreed with orders passed in I number 1 in RA number 117 of 2020 dated 11/7/2022 by the, which court is this?
Let's, this is
By the Principal District and Session Judge.
7th additional district and session.
Huh?
7th additional
7th
district and session judge.
Belgavi. The petitioner, the petitioner appellant is before this court. The suit, the respondent herein has filed a suit for partition and separate question that came to be decreed. Against that, the petitioner herein has preferred an appeal before this court. That is
It's RFA.
RFA number 1000099 of 2020. The office has raised an objection with regard to the maintainability of the appeal. And this court has directed the office to return the appeal for representation before the appropriate court, and 6 weeks time is granted for representing the appeal before the appropriate forum. The petitioner, it is a case that the petitioner has represented the appeal before the court within 4 weeks. And in that, he has filed an IA to stay the operation and execution of the judgment and decree dated 13/12/2019 that came to be dismissed by order impugned, wherein the court has observed that the limitation from 15/3/2020 to 2022 is excluded. The appeal should have been filed prior to 15/3/2020. But though the applicant obtained a certified copy of the impugned judgment and decree on 9/1/2020, the appeal was filed on 25/8/2020. Instead of filing prior to 15/3/2020, therefore there is force in the contention taken with respondent number 1 regarding the delay in filing the appeal. Hence, unless the delay is condoned, the stay order cannot be granted as prayed for. Therefore, IA reserves to be rejected accordingly. The court had. So what we will do is we will set aside this order and remand the matter. Let the court consider.
In view of interim order that was already subsisting on IA number 1, that could be modified and stay of operation and execution is already in force. Let it can be continued and appeal can be disposed of on minutes. Again, hearing on IA would take time.
Since 2020 appeal is pending, kindly add the file court, appellate court.
Counsel appearing for the petitioner's office after the High Court has passed an order immediately. He has filed the appeal and because the court has failed to consider the application, it is submitted that by virtue of the interim order granted in this court, there is a stay of and decree. It is submitted that the same may be continued pending disposal of the appeal, and if the appeal is heard and disposed of, it would be in the interest of both the parties. Land counsel appearing for the respondent plaintiff submits that
Within a reasonable time of 3 or 4 months, dispose the appeal.
Appeal of which year? 2020.
2020.
So many appeals in that court.
But in this case, at the fag end, at the time of argument, he questioned it. No doubt.
Not me. They questioned that and the order is passed. That order was already in
the month of July, order passed. At least 3 or 4.
That there may be a time frame fixed for disposal of the pending RA. For having the counsels on either side for submitting non-record. And the petitioner has immediately approached the court by filing the appeal pursuant to the order passed in RFA. The court ought to have entertained the court ought not to have taken objection with regard to filing of the appeal on the ground that there is delay. That apart, right? This petition is filed in the year 2023. From 2023, there is stay and there is operation. There is an interim order where there is a stay of operation of judgment and decree. Considering all these facts and in the interest of both the parties, this court is passing the following order. The order dated so and so, passed by so and so, set aside, and there shall be the interim order passed by this court on which date?
It was granted on 29/5/2023 minutes.
29/5/2023 shall operate during the pendency of the RA. The appellate court shall dispose of the appeal within a period of 6 months.
Please.
From the date of receipt of the copy of the.
My apology that instead of 4 weeks, it has to be 6 weeks. 15/9 was the order that was passed returning. On 25/8, I have filed it. It comes to 6 weeks only.
Yes, next.
Seal number 41, Reshma Madiwala.
My lords, I am representing the petitioner, my lords. I am seeking a writ of mandamus directing respondent number 1 to 3 to hand over the investigation from respondent number 4, who happens to be the circle inspector of Sandur police station, my lords. On the account, FIR is registered under section 302 of IPC, my lords, on the account of murder of my father, my
What
lords.
is this? Why are you asking this prayer? To hand over the investigation from the respondent number 4 and hand over the same some other investigating agency.
Yes,
Not-
madam.
What is this?
Your Lordship,
Kindly
now
please look into page number-
investigation is completed, Your Lordship. Charge sheet has been filed now, Your Lordship. It is their allegation that the investigating authority is not properly conducting the investigation. But, as per the document which they have produced in the annexure D post-mortem report, Your Lordship, it is clearly stated, Your Lordship, death is due to asphyxia as a result of hanging, Your Lordship. Their allegation.
24. Please,
Please.
the petition is filed saying the following prayer.
My lords, kindly please look into page number 28, my lords.
The
The
respondent,
photo, my lords.
it's submissive. Already the entire investigation is conducted and
CC 863 of
charge
20.
sheet is filed and the same is numbered as CC number
863 of 2025, Your Lordship.
863 of 2025. 2025. In that view of the matter, if the petition is agreed with the said charge sheet, is at liberty to question the same.
Please.
Accordingly disposed of. Yes, next 42.
Appeal number 42. Santosh B. Maliwad.
My lord, I appear for the respondent, but I'm seeking a short accommodation, my lord. I'll place my objections on record.
Yes, list this matter on 24th of March.
Please. I'm grateful, my lord.
At the request of London Council, the respondent is 43.
Appeal number 43. Appeal Staley. Sandeep Patna.
Kindly pass over, my lords.
No pass over today. What is the urgency? Why you moved the memo?
My lord, senior is coming. He'll argue the matter.
If he comes before I raise, I'll take no pass over.
Please.
If not, adjourn the matter. Yes, next. 44.
44.
My lord, this is yesterday's matter, my lord, regarding deposit. I have, my party has drawn the DD, my lord, he's on his way. Out of 8 lakh rupees, my lord, 4 lakh is deposit.
Matter on Wednesday, it is submitted that today his party is on the way and getting the amount.
Yes.
The same shall be, that is permitted to deposit the said amount before the registry.
Yes.
Yes. List the matter on Thursday, we'll see.
Please.
Yes,
Obliged.
next 45.
Appeal number 44. Sorry, appeal number 45.
Yes.
Please.
Where is the other side? Ready?
Yes, Shubhen.
For the respondent. On behalf of Santosh Nargumars.
You're ready, I'm not.
Next week, Mars.
Lords, there
You
is
have an
urgency,
interim order?
Lords. This has been happening since past 4
You have an
days.
interim order.
Yes.
No, there was an interim order, but was not extended on one occasion, Lords. Therefore, it is intact. Lords, an interim order, the same interim order which was granted earlier, maybe was granted because now the
Order granted.
Lords 6 to 25, Lords.
Till when it was it is not, you're not having interim order from a very long time.
Lords, what has happened on that day?
No, not
We
that
were,
day.
no, on
Matter
one
came up
occasion.
On 11 to
Lords, or else, Lords, may please to hear it today, Lords. I
2
will.
to 21/1, 21/1, 2026, 23/4, 2025.
Yes,
You don't have on 9/4, 2025. You don't have an interim order on 2/4, 25/3.
It was,
Two.
Lords, it was listed before, Lords, only for on 4, 5
Where is
occasions.
the interim
Lords.
order that you tell the court?
Lords, 6 to 2025, Lords.
6 to
2025.
issue notice. Further proceeding pending so
Please.
till next date of hearing.
Please, Lords.
You are not having from exactly 1 year.
Lords, it was.
Matter was listed on 25/3. On that day itself, it is not extended. From the last
Lords,
1
what has
year,
happened?
no.
Lords,
It can wait.
Lords, may kindly please hear it today itself, Lords. I'm ready with the matter, Lords.
List this matter on 16th of March.
Lords, at least on Monday, my Lords, at least he'll be appearing, Lords. Any short accommodation, Lords, because the trial court is proceeding. Today, the matter is listed before trial court, Lords.
List the matter on Tuesday.
Please.
46. Yes, next 46.
So I'm filing objections. May I pass on objections? Objections in this case.
What is that?
Objections.
Objections.
Rowdy sheeter, my lord. My lord had heard and
Take that.
Lord, against the petitioner, there were 3 cases, my lord. One was with respect to not wearing mask during COVID time, my lord. And
Let me look at it. What they
yes, yes, yes.
What is this NMPS crime?
No, New Market.
Police station.
Huh?
New Market Police Station.
What does it mean?
That's a police station name. New
Police
Market
Station name,
Police
New
Station.
Market Police Station.
How in rural areas, my lord? The urban station will be there and rural station will be there. That's all.
He is accused in CC number 1449 for not wearing the mask. They
The
filed
3
charge sheet.
crimes were there. 3 crimes were there. All have in 2 he has got acquitted. There is only 1 case pending. That's it. Other than 1 case, no case is pending. Police themselves have filed B report, my lord.
When was the last crime?
Lord,
Latest crime is on 2025 is also there.
that is B report is filed. In that also. Last crime is 2018, my lord. That is under trial.
What are the parameters for opening?
There is a guideline.
Guidelines and Miller's order now 1059. Please.
Yes, there is a guideline.
Policeman.
Guidelines.
I pass on.
But page number 56 of it, there is a clear guideline. 56. $56 million.
Yes.
56. My lord, I will go to the relevant portions, my lord. Paragraph number 2 in that. Brief proposal shall be sent to the individual concerned in a sealed cover with an option to submit his representation within 2 weeks as to why his name should not be registered as Rowdy. However, there is no need. Second one, the third one. In clause 5, order dated so and so, the superintendent of police of subdivision police officer shall not accord approval of entering the name of individual concerned to the register of rowdies without calling for record and objectivity considering
That stage you have crossed. Now the second is after when the rowdy sheet has to be closed, which deals with that.
Lord, in this also it was challenged. It was removed, then the name was removed by setting out following guidelines, my lord. Now,
No, you are not questioning opening a rowdy sheet. What are you questioning?
that is I have asked them to remove.
Rowdy sheet opened against you.
Well, that information will not be given to us. That's their own procedure. That's how this guideline says.
No, they will come. They will every time whenever there is, they will ask you to come and sign.
That's the reason, my lord, I made an application under RTI. They have given a reply. Kindly see that reply, my lord, what they have given.
Let us see the rules. Which rules
Please,
are there?
1059.
Lord, I will just take through this,
1 minute.
the information given by.
1059 of the Miller's the manual.
1058.
1059.
59.
Page number 571.
Register of rowdies.
Rowdies. A rowdy may be defined as a gunda and includes a hooligan, tough and vagabond or any other person who dangerous to the public peace and tranquility. The main forms of rowdyism are passing indecent remarks at women and school and college girls, intimidation of law-abiding people by act of violence or by show of force or by abusive language, forcible collection of subscription, taking sides in petty quarrels between the landlords and tenants or between the co-tenants and threatening people of the opposite party, disorderly conduct, rioting, snatching and committing of robbery. Every police station, a rowdy register of rowdy should be maintained in form number 100 in 3 parts, Part A, Part B and Part C, which should be in separate volumes. All the volumes are to be treated as confidential records. The names and particulars of the confirmed rowdies who are the residents of the police station concerned should be entered in the register of Part A, a few pages being allotted to each person's. Next minute. Names of particulars of the confirmed rowdies who are not.
So seven deals with.
7.
when there are one or more instances
of rowdyism against any person, or if he has very bad reputation in the
Very bad
locality
reputation.
as a bully, or his name entered in Part C on the ground of the very bad reputation, a thorough inquiry should be made by the officer in charge of the police station before the entry is made. In a running history,
That's what the guidelines, it says, there has to be an inquiry. My lord may see.
Oh, before looking at it, let's see what is the, first of all, what are these called? Police manual.
Police manual.
See,
Please. That's relevant, my lords, provision subsection, my lords, order 13 of my lords, next page, my lords, 573.
so whenever a rowdy sheet has to be removed, 13 deals with that.
Yes.
No name should be struck off from the part A or B and the rowdy register without
Order of writing with the
writing
superintendent of
superintendent
police
In such cases, the inspector should send the recommendation.
to the superintendent of police through a subdivisional officer. My lords, that he has to make an application to
I have
the
made an application.
to the SP. He has not produced any document to show before this honorable court. He has made an application to the SP. My lords, let him make an application to the superintendent of police.
It's on record, my lord. Kindly see page number 8, 9 in the last line I have.
The sheet of suspect should be maintained from the date of registration up to the end of December, after which the orders of a superior police officer as to their continuation of so and so. So,
Yes.
now here it is.
Please.
Now, a history sheet or a rowdy sheet is open.
Yes.
Now, it is not that till they make an application, we will
Yes.
retain it.
Yes.
Periodically, there should be an evaluation of the rowdy sheet.
Yes.
In fact, in Telangana High Court, I
Yes.
have passed a detailed order. Several of the rowdy sheets are reviewed and closed. So you just, for eternally, you can't keep the rowdy sheet opening.
Yes.
So you have to tell.
Yes.
Now, when was this opened? After that, what was the review conducted? And what the file discloses?
My lords, the instructions which I have received, my lords, seeing page number 2 of my statement of objection. The rowdy sheet opened on 19/12/2020.
1912?
2020.
19/12/2020. So now there were 23, 24, 25.
Yes.
The review should have been on 3 occasions.
Yes.
So where is that review I want to see? Ask him.
Statement of objection copy may also be directed to be given.
Unfortunately, he cannot give you because they don't review it.
Yes. Also, the one judgment of this honorable court says. So the division bench judgment of this honorable court. B.S. Prakash.
And that judgment will not say something
Yes.
contrary to your own
Yes.
manual.
Yes.
Because your source of power to open the rowdy sheet is your manual.
Yes.
You are
That
bound
is-
by it.
Yes.
Manual says there has to be a periodical review on every December, whether you have done it or not. If you're doing it, do it now.
My lords, since he is a continuous offender, in the 2025 also, my lords, there is a case against him, my lords.
Report is filed.
Let me,
Quash agide adu.
Let him submit. You will get an opportunity. Yes.
my lords, the only apprehension is that, my lords, he is a continuing offender.
This court will not pass any order asking you to close the rowdy sheet.
Yes.
This court is only concerned with whether you are adhering to the procedure laid down under the
My lords,
enactment,
my submission
manual,
will,
whatever it is.
my submission, kindly give a 1 week time, we'll make a officer to review this.
What I'll do is, I will take up this matter on Thursday, on Friday I'll take, on the last working day, I'll take up the matter. By the time they should come up before the court, please list this matter on Friday. By the time the respondent shall place on record, whenever a history rowdy sheet is opened, what is the procedure to be followed? As per the manual, there has to be a periodical review in the month of December, whether they are doing it or not. If they are doing it, what is the review that is done in case of the petitioner? Then the same shall be placed before this court. The last crime that is registered against the petitioner is in the year 2020. And in one crime
25.
that is registered in 2025, police have filed a B report. In the backdrop of this, the respondent should place you there.
No, that's factual. It is quashed by High Court.
Which one?
2025, which was registered. Yes, they themselves are saying it is quashed by the High Court itself.
2025 is quashed. In which B report is filed?
Another in 2023. They have,
Give him a copy of it.
they will not provide. I have to make RTI application. Then they will provide.
Look at it. 2025, that is quashed by the
Please.
High Court.
Yes.
You search for one judgment where the detailed guidelines I have issued in the Telangana High Court. You will get it.
It would be a research for me also.
Please do that.
But may I request one thing? It may be taken up in further hearing, my lord, since my lord has heard it.
Part heard.
Part. Great.
And why he has not given instructions? What is his problem?
I took recently charge as assessor.
Huh?
He has taken the charge recently.
Ask him to come before the mic.
Recently, I took as a SHO of the station.
When have you taken charge?
In the month of ninth month.
So even if you have taken a day before the court order has passed, are you not supposed to come to, either you have to instruct him or you have to come to the court? Why did you not do it? For that, you don't require any other any other orders from your superiors when the High Court asks you to come to the court. Now, for this kind of conduct of yours, if this court passes any order, it will go into your service register. Are you aware of it? Then why did you do it? Shall I ask your higher officials to take action against you for this kind of?
Sorry, ma'am. It
You
won't be
have to be
repeated again.
henceforth be very careful. This is not the way you behave. Being a responsible officer, you should know when the High Court, when you receive a communication from the High Court, you are bound to come to the court.
Yes.
Court is not asking you to come, asking you to give the information. If you don't, then you should come to the court. You have not come. You have not given the information. You should have come.
Yes.
Yes. By that time, I want on Friday.
Yes.
Seal number 47.
Like a lot of cooperative societies.
Why, who moved the memo?
My lords, me, my lords.
What is the urgency?
My lords, the Honorable High Court has been stayed the counting of votes, my lords.
Only?
The vote counting has been stayed by this Honorable Court, my lords. The election
Where is the
process has been
order?
already commenced.
Issue emergent, the petitions are before the using several in support of the interim prayer. The votes that are casted by these respondent number 2 and would remain subject to the result of the votes cast by them will be placed in a separate seal cover and will be open. Why do you say that their votes can't be counted?
The reason is that, my lords, one, the respondent number 4 and
Use
5.
the mic, keep it properly.
Lords, the respondent number 4 and 5, one is a nominee and one is the returning officer. Returning officer has also right to vote. That is, my lords, the
Respondent number?
4 and 5, my lords. Sorry, 5 and 6. 5 and 6.
5 and 6.
Returning officer.
He is a returning officer, my lords, as per the bylaws of the society. He has also right to vote. That is what my contention urged before this court. That is, the bylaws are in Kannada and impugned order is also in Kannada. Only my request, my lords, this is the impugned order. As per this impugned order, my lords, the respondent number 6 has been appointed as a nominee. My friend has taken a certain contention before this court.
You say
Please.
the order of
This court.
the other learned judge says
Please.
the petitions are before this court, urging several grounds in support of the interim prayer, directing restraint on respondent number 2, 5 and 6
Please.
to cast their vote.
Lords, my contention is returning officer, he himself cannot vote, my lords, in the same society.
My lords.
He himself was, that is one contention.
That's one contention.
Please.
So that is only that is where it is kept.
Please.
What is your
My lords, with respect to respondent number 6, respondent number 6 is the financial agent, my lords. Agency. He is the nominee of the financial agency.
Let's see who are the respondents.
My lords, respondent number 2 is the ARCS.
Let's look at it.
Yes, my lords.
Lords, respondent number 6 is one Shekhar Shivappa Hakaldadi.
Number
6.
respondent number 2 is the assistant registrar.
Register Cooperative Society, my lords. And also later, my lords, no, my lords. Here, there is one more order which has been passed by the cooperative society, but that has not, that has been suppressed. I have produced the document of it.
Notes, I request.
There is one, first I'll go with
It is
this.
so specific to the interim order. Interim order is 2, 5 and
2,
6.
5 and
Their
6.
votes are kept and you
Yes, my
want
lords.
that order to be vacated.
Yes, my lord.
So second respondent, can you vote?
Now, I am for the sixth respondent.
Huh?
I am for the sixth respondent.
So
over
second
here.
respondent, you are not concerned. That interim order of second respondent.
Hearing for the second respondent, assistant registrar. For respondent number 1, 2, I'm appearing.
2, 5 and 6. Sir.
Five.
So second respondent, he cannot vote in the election. So this, why was the?
Note, sixth respondent, my lords.
No, why second respondent? Why you are saying that second respondent is going to cast the vote?
Notes, as per the bylaws, it is there in my society bylaws where the respondent number 3, 4 society, he is one of the ex officio member of that society.
He can cast vote.
He can cast vote. So, my lords, my friend is produced certain documents to show that, my lords, there are subsequent developments. He has provided, I informed my party to get the informations, but I could not get, he is not turning up. I had addressed a letter. I request next week, any date, my lords, I will make a submission, if that is true.
This has been come from the long time.
No, my lords, I am not disputing the fact. This has came earlier also.
My lords, the first thing is he is challenging the order of the communication. He is challenging the election process which has already been commenced, first of all. And the second thing is he is challenging the communication order which has been passed by the respondent number 4. The respondent number 4 order, what the order has been passed is annexion number annexion number C, my lords. Here, the respondent number 4 is the cooperative society. Respondent number 3 is the bank. The bank has nominated respondent number 6 to as a representative of this respondent number 4, my lords. Here, the same order has been accepted by the petitioner himself. The meeting has been passed. The minutes of meeting has been there.
Signatory to that.
Yes, he was the chairman to that. He was the chairman to that society.
Pass on.
Pardon, my lords?
You have that.
Yes, I have produced
Let us see.
in the objections itself. Annexure R6A. The translated copy.
Page number?
8, my lords.
Huh?
8.
Let's see.
On 8/7, my lords, the communication letter was dated 5/7/2020.
Find the petitioner's name.
Here, my lords. Jamakandi Upa Vibhaga Janata Consumer So and So. ಜಮಖಂಡಿ ಈ ಸಂಘದ ಕಾರ್ಯಾಲಯ ಶ್ರೀ ಸಿದ್ದಣ್ಣ ರಾಮಪ್ಪ ಬಿಳ್ಳೂರ್ ರವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ನಡೆದ ಆಡಳಿತ ಮಂಡಳಿಯ ಸಭೆಯ ನಡವಳಿಕೆ. On the first paragraph itself, that was been chaired by the petitioner himself. He has accepted the notice.
So where are you getting it?
First paragraph itself, my lords.
Looking at your translated copy. In that I don't find it.
Before column, your lordship, first, before column.
After the date.
No, this is a translated copy. In that I don't find it. That's what I'm saying. Jamakandi subdivision wholesale so and so. Proceedings of the governing body meeting held under the chairman Siddanna
Ramappa Bildur. He is the petitioner. That meeting was been chaired by this person itself.
Let us read it.
Pardon, my lords?
Let us read it in English. Please read it in English. On 8/7/2024, the in-charge manager proposed to the meeting that the nomination and direction of the DCC bank representative had been sent by the Bagal court. After discussion in the meeting, as per sub rule 37, financial institutions are allowed to become members of the board of directors as per the order of the letter from the Bagal court.
Bagal court.
In the meeting, nomination of Sri Shekhar Shivappa so and so.
The respondent number 6.
Include the DCC bank representative as the director of the board of directors of this association. Yes, Mr. Counsel.
Lords, my contention for my lords is, this is accepted, my friend is submitting. Lords, as per my lords, the rule, that is the section that I will take my lords to the.
Why are you a party to this?
Lords, I was a secretary. I had informed my party, my lords, a trial court advocate has referred this matter. I had informed to get whether this is shared by me. Even if it is shared by me, my lords.
This is matter on Wednesday.
Yes.
By that time, the petition shall get specific instructions. Whether
My lords, kind submission, my lords.
you can't we have to give other side a chance finally.
Yes, my lords, empty number of time is already been granted by this
So what do you
honorable court,
expect
my
the
lords.
court, no, whatever you are saying that has to be
Lords,
taken.
even
and
if that my friend is,
Everything is on the face,
But
my
I'll
lords.
tell
That
you,
is
but
what
I'll
has
tell you,
happened.
the petitioner is seeking the time at his own cost. Monday, when the matter, when I hear this matter, I'm going to impose exemplary costs on this petition for having chaired the meeting. You can, you will be having the details in your office. It must have been forwarded to you, all this. You get the original record.
Please.
This is matter on Wednesday. By the time the HCGP shall place before this court the original record pertaining to the meeting dated.
Dated, your lordship.
Dated is not there.
8/7/2025.
8/7/2025. Land counsel of the petitioner seeks time to get instructions whether the petitioner has shared that meeting. If the record reveals that.
8/7/2024, my lords. I apologize.
Give the date
8/7/2024.
8/7/2024. If the petitioner has chaired the meeting and contrary to the resolutions passed in that said meeting, he has come before the court and sought these kind of reliefs, exemplary costs will be imposed by this court.
Lords,
This
one
is
more
not-
submission. Lords, one submission.
This is
Even if
not
that is
done.
accepted, my contention legal ground which is covered by this court of this judgment.
We are not concerned with other things. We are concerned in the writ petition
Please.
under 226 about the fairness.
Lords, I am not saying fairness. Even if that is, Lords, I am,
We are concerned with only fairness first.
Please.
First the hurdle of fairness you cross, then
That-
the merits.
please.
Yes. On Thursday.
Please.
Yeah, no excuse.
Please, your lordship.
If the record is not placed, consent shall be present before the court.
Please, your
Yes, for
Seal
48.
number 48. Subhash Jabati. Siddhappa S. Sajjan.
Please, ma'am. My lord, I'm sought for the CCTV footage of the accident, my lord.
Huh?
CCTV footage of the accident spot. Here, my lord, that claimant's respondent has filed a claim petition sought for the claim about the 2 crore rupees.
Under order 16 rule, 6 and
16
7,
rule.
playing to issue summons, police station to this pertaining to the spot of the accident.
Please, ma'am. My lord, on the face of record, complaint and FIR seems to be that, my lord, the vehicle is involved.
This is an MC of 2023.
Please.
Yes, ma'am.
Maintain the footage for about, you know that the CCTV footage will be there only for 6 months as per the Supreme Court guidelines.
My lord, the criminal case is already on record. Criminal case is running. Still, the witness has not been examined in the criminal case. Till then, my lord,
In this criminal case, why CCTV is a part of the footage?
no, that might be possible, my lord, that they may have kept the photographs and all these things. At least, my lord, that presiding officer should not judge before that the judgment is. Let the
CCTV footage will not be available. That is a.
no, that are photographs, any available that, my lord.
What is the application?
My lord, I'm
Court
sorry
will
to-
not grant any of it.
No, my lord, CCTV, I have specifically asked for CCTV footage.
Let us see. Insurance company is contesting the matters
No,
like
my
a
lord, in
criminal
this case,
trial.
what had happened, madam, in this case, my lord,
Let's see what is your application. Please come to your
please.
application. All strange applications are filed.
No, my lord.
Where is that
Case 51.
50?
1.
From tomorrow you will be crossing, you want to examine the judge also who has passed
No,
the.
this is not why I am asking that we have suspected the fraud because that the vehicle is not been involved in this case.
Let's see.
In now, my lord, the
we
recent
have
master
specific-
posted for argument.
For the respond, I know the facts of the case. Read that.
My lord, please issue summons to the following persons, his concerned authority CPI Navnagar Bagalkot to produce the CCTV footage of the date 2/8/2023 between the 5 to 6 p.m. relating to the accident.
In CCTV footage, that's it. You didn't ask for anything.
No, my
Please
lord,
come.
but just a moment, my lord. I will see. On the prima facie, my lord, complaint and the FIR seems to be that the union case. When you have come to the charge sheet, my lord, may I please page number 44.
Understand. You asked only CCTV footage by
Yes.
way of this application. You have not asked anything. Court was right in saying that the CCTV footage beyond 6 months won't be there.
Yes.
Because even the Supreme Court has directed all the police stations to maintain the CCTV footage only for 6 months, not beyond that.
No,
This application is filed after 2 years.
My lord.
So no useful purpose would be served.
My lord, my evidence is not had been commenced. Before that, my lord, I have produced, I have filed application.
So whenever you have.
No, my lord,
Agreeing with the orders passed in I number 7.
My lord, it seems that, my lord,
His
out
evidence.
out of 19 witnesses, sir, there is no any single eyewitness in the charge sheet witness is recorded. Let the concerned officer might be some statement will be recorded. Then, my lord, the court may be taken pass the order, given that a fair opportunity to me.
I think you are not understanding
No,
what
I
exactly
understand,
I've
madam.
asked
Supreme
you.
Court
No,
guidelines.
not Supreme Court guidelines.
Please, madam.
What is this IA?
Pardon?
For what?
I have forgot summoning the CCTV footage.
And then CCTV footage, that's what is the order. And where is the question of police officer coming and deposing before the court? When the CCTV footage you asked, that won't be available after 2 years. What is the purpose of calling him? If there is any other purpose, you would have stated so in your petition.
That, my lord,
The IA number 7 is filed in MVC number 5 and 3 of 2023, seeking to under order 16, rule 6 and 7, read with section 151 CPC, to issue summons to the CPI Nagar police station to produce a CCTV footage pertaining to the spot of the accident alleged dated 2/8/2023 between 5 PM to 6 PM. The court has dismissed the application on the ground that whether or not the accident alleged occurred involving the vehicle owned by the respondent number 4. Enough material. Moreover, the accident occurred on 2/8/2023. Application is submitted only on 29/2025. Therefore, it is highly impossible to any department to maintain the CCTV footage for about more than 2 years. Moreover, the respondent number 2 in the application has nowhere mentioned the reason as to why he could not maintain the application of the present nature at the earliest point of time, in that there would be chances of retaining the CCTV footage by the department, and in which the purpose of filing the present application would have served, and accordingly dismissed. Learned counsel appearing for the petitioner submits that the court at a threshold ought not to have dismissed the application. The court ought to have allowed the application, and if the officer is summoned, he would be bringing he would be submitting before the court. In the facts and circumstances of the court, the summoning the officer for placing the CCTV footage is very much essential, which is not considered by the court. When counsel appearing for the respondent submits that.
Further, madam, further under section 134 of C, that is the primary duty bound, the police officer have to be intimated the insurance company. In this case, madam, they have not been intimated.
That is your advantage. How can this
No,
application is concerned
that
with
will
it?
not be considered in any judgment, my lord, because
What you
after 6 months, my lord, they filed the claim petition. And
you have to understand, whatever you submit, this is not going to change. So you better leave it there. Yes, the land counsel appearing for the respondent submits that the court has rightly considered and passed the orders. No interference is called for. Next, having heard the counsels on either side, peruse the material on record. The petition, the accident had taken place on 2/8/2023. The present application is filed on 29/2023. The court is right on dismissing the application that the CCTV footage storage will not be beyond 6 months. The Honorable Apex Court has also issued guidelines to all the police stations to take the CCTV footage for 6 months. The court was right in observing that initial stage of this application is filed. The court, as it would be for 6 months, the court would have passed orders asking the police to retain the CCTV footage. No useful purpose would be served in allowing the application. Hence, the court had rightly dismissed, and this court finds no reason. Yes, next. Next.
Number 49, being so much. Rowdy.
It is the petition filed by the defendant number 3, my lord. Petition filed by the defendant number 3. And the impugned order is at page 18, my lord. 18. 18. Yes, 17 and 18.
And the facts and circumstances, no sufficient ground made out to allow the application. What are the facts of the case?
That the present plaintiffs have filed a suit for partition and separate position, and also declaration to declare that the sale deed executed in favor of defendant number 3 in respect of one property is not binding on them, etc. The defendant number 3 is the purchaser of one of the property. The plaintiffs have filed the suit for partition and separate possession, including the property sold to the defendant number 3. And they have sought for declaration also to declare that sale deed executed in favor of defendant number 3 is not binding on them, etc. The defendant number 3 has appeared. The notice of the day.
This matter is about after the amendment to the CCTV.
Yes, after amendment of the.
Court has no discretion. I have dismissed so many petitions.
Because only.
And until you question the amendment and unless and until that amendment is clarified or set aside or declared as.
Here in this case, there is no delay even at all. The notice of the said suit is not served on the present defendant number 3.
When did you receive the summons?
It is served on the father of the defendant number 3. Defendant number 3 is working at Chennai. And the notice of the said.
Father take the summons. Why did your father take the summons when it is not belonging to him?
Because
Father has taken the summons. You have a knowledge of it.
Yes, on 18/7/2025.
7?
18/7/2025 notice has been served on the father of the defendant.
20 days finished.
And on the next day, the intimation was given to the defendant number 3 on 19/7/2025.
120 days completed from 18/7/2025 or not?
120 from 18/7/120 complete.
That is what?
120 days complete. But one looking to that if you consider that on next day, it has been intimated to the defendant number 3 and taking into consideration that aspect, it will not come that is 120 days. On 120 days.
Any interim order is there in there?
Yes, interim order is there.
No, this interim order is not extended. 19/1/2026, no interim order extended.
That is on 12/12/2021.
12/12 also, it is only state till the next date of hearing.
Yes, on 12/12/2025, the interim order was passed by the Honorable Court and granted a stay for further proceedings. On the last date of.
Post of my lords.
It can't be disposed of, it can only be dismissed. Is this matter in the month of April? Interim order only granted is extended. Case 50.
Interim order is missed.
Please.
Cell number 50. Vishwanath Bhatt. Ganpati Bhatt.
Please. The cooperative society election matter. Election is already conducted on 1/2/2026, only for pending declaring the result of the cooperative society.
No objection to.
You appear for whom?
Respondent number 5, my lord.
5 is who?
Society.
Where is the returning officer? Now, this is with regard to the voters list.
Please, my lord.
Then,
Non-eligible.
non-compliance of that.
In this,
Is it there is not 13 or what?
In this petition, your lordship, they have not availed the loans and they have not taken the use of the society and they have not attended the meeting, your lordship. For that, they have.
Unless and until that is determined, how can we say that the votes have to be counted?
Please, your lordship.
Who is the concern? Is a notice served on them?
Sorry, your lordship.
Which respondent?
R6.
R6 is who?
First matter, respondent number 5 is the society, my lords.
Vagishar Heg.
Please, ma'am.
Where is he?
I am the respondent number 5, my lord. Saraswat.
No, it says respondent number 6.
Kenra Saraswat Cooperatives over the society.
Respondent number 6 is who?
They are the petitioners are the member of the respondent number 5, my lord.
Respondent number 6. There is no respondent number 6.
First matter, respondent number 5. Respondent number 5, and in second matter, I am the respondent
Number 5 is this returning officer. Where is the returning officer? 4 represented by whom?
G.V. Barmagaudar, sir.
Why these people, they don't even file the wakala? Returning officer must be somebody connected with your department.
Your lordship, returning officer is from government itself, your lordship,
That's
but
what I'm
as he is a part of election, your lordship, we usually.
No, whoever it is, you should inform them. Inform
GV
them
Param
because
Gowda is an independent advocate, your lordship, who is.
They will inform your concern over the
Officer.
department. Because unless and until we say that whether they are qualified, disqualified, how can we direct them to count their
Count the
votes? In the other matters where they said that there is no compliance of Rule 13 or what?
13D, your lordship.
13D,
no
that's why it
complaint.
is all allowed.
Please, your
But it is a different thing,
Different
which has to be decided.
Please, your lordship. I will ask, I will get instructions.
The respondents will file their objections. Yes, list this matter on 11th of March, please. Yes.
One submission, my lordship. In this society election is earlier management period is over on 22 of this month. After I have to appoint the administrator, the effect the society, my lordship, issuing the loans.
Respondent, as it is submitted that the term of the society, term of the
Earlier
body
management.
is expired on
22nd, my lordship,
22nd
of this month.
of February. The respondent shall take appropriate steps for the
Please.
management of the which respondent?
Fifth respondent.
Fifth respondent, Cooperative
Fifth
Society.
respondent.
Yes. 51.
51 for dismissal. Manjunath.
Lords, advocate on record, my lords, is not well. She is seeking short accommodation, my lords.
To quash the order dated. What is this?
Your lordship, earlier matter was heard, your lordship, and auction was called out, your lordship, and they have tried to, she has stated that they will try to settle the matter. Amount, your lordship, of
And
rupees
list under the same
30
caption on
lakhs.
Friday. Same caption Friday.
Please.
Yes.
27.
See, in that withdrawal matter has come.
Filing memo for withdrawal. Petitioner is present.
Yes. Take that. A memo is filed stating that the petition, the respondent being the brothers, to maintain cordial relationship with the respondent. The petition is not interested to further proceed with the matter. Hence, the petition may be permitted to withdraw the petition. The petitioner is present before the court. Identity, other petitioner is present before the court.
ID card. ID card.
Is present before the court. Accordingly, the petition dismissed as withdrawn. Yes, any passover matter is there that you give after, maybe on 24th of March.
My lord, may I submit?
Yes.
My lord, serial number 20 urgent, unattended, my lord, matter is urgent. I am neither the borrower nor the, my lord, guarantor. My lord, my property has been attached. I was held up in some other court, my lord. Kindly have it.
Matter on Monday.
Two.
Yes.
Much.